Sorry, 7.
But I'll have your I don't know if I want to do the first one first, just to get that.
Okay. Loretta, we're going to do the resolution first.
Oh, good.
Okay, so, all right, so you'll read that. Yes. Why are we being filmed? That's why I'm asking Marty. Marty, why are we being filmed?
I mean, it's already live stream, so.
I know.
Yeah. As long as they're not obstructive or anything, that's right.
Where did you run to New York to get the passports?
How are you?
You don't. Weren't you going to Italy? Wait a minute. How were you going by way of? Oh my God. Okay. She wants me to call the meeting to order. Okay, I'm going to call. I'm going to call the meeting to order, Mark.
Assuming they're going to go forward, you mind if I sit up here when I ask questions?
Okay. That's up to them. No. I'm just introducing special counsel.
The whole family have to fly to the back?
But I'm just,
Mark
I'm
and Jeffrey,
just going to do an
did the whole
introduction.
family
say
have
what
to
the
fly?
council asked me to do.
Oh, okay.
And then the planning board.
Passports?
Yeah, that's all. I'm not substantively.
Oh my God.
Right.
Sure, you're not taking over my
I'm
seat.
so sorry.
Marty, I want to be like, there's only so many meetings I could go to. So that's it, Chuck. I mean, that's up to them.
Right.
I assume they'll let you know.
No. Where in Italy did you go?
No, I'm sure they have a process. You come up, whether he or he. I'm sure there'll be time.
So I have a quick question for you.
Yeah.
TC still override or Huh?
I think so.
Yeah, but does it handicap, you know?
Yeah.
Yeah, that's what I thought.
They should reject it.
I know. That's
Okay.
ready.
Yes.
Can I begin? Good evening and welcome. This is the September 5th, 2023 Holmdel Planning Board meeting. Please, roll call, please.
Mr. Aquiliano? Mr. Aquiliano is absent. Mr. Ackerson?
Here.
Ms. LaMountain? Ms. LaMountain is absent. Mr. Fagan?
Here.
Mr. Castaning? Mr. Castaning is absent. Mr. Emma?
Here.
Mr. King? Ms. Pelosis?
Here.
Mr. Silverman?
Here.
Ms. Polavina? Ms. Polavina is absent. Ms. O'Connor? Ms. O'Connor is absent.
Could everybody please rise for the Pledge of Allegiance? I
Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And can you please remain standing for a moment of silence to honor our military, police, and first responders? Thank you. Rita.
In accordance with the Open Public Meetings Act, NJSA 10:4-10, and the regulations governing remote meetings, NJAC 5:39-1.5, I hereby announce that adequate notice and electronic notice of this meeting was provided in a notice dated January 24th, 2023, that was sent to the Asbury Park Press, Two River Times, posted on the bulletin board and on the main access door to Town Hall, filed in the clerk's office, and posted on the township's website. Public hearing is going to be, the chair changed the order. We're going to do the memorializing resolution first. Item number 2, PB 2023-B, Swing Loose LLC, 101 Crawford's Corner Road, Block 11, Lot 3807, preliminary and final site plan approval. Applicant approved for preliminary and final major site plan approval to memorialize Phase 1, consisting of the existing 27 hitting mats, and permit the development of an additional 7 hitting mats to the existing conditions at the property.
So this was circulated amongst all the professionals and the board. Applicant's counsel is here. He had a couple little typos we'll correct. And our engineer's not here, so he wanted to just confirm if the affordable housing component was already satisfied with the redevelopment of the property itself, which I believe it probably is, but we're going to get that concurrence tomorrow. Assuming we get that, we'll just make a notation on the resolution that that component was satisfied previously.
Okay.
Any other comments?
Is there any comments regarding the resolution? Do we have a motion? Oh, you weren't here. You weren't. You were here.
Motion to approve? Second.
Okay, so, Mr. Fagan?
Yes.
Mr. Emma?
Yes.
Mr. King?
Yes.
Mr. Silverman?
Yes.
Thank you.
Item number 1, public hearing. Area in need of redevelopment, investigation report for Block 27, Lot 7, former Nokia Crawford Hill facility.
Excuse me, Miss Sir, you can't have that light on. It's blinding in our eyes. Matter of fact, if anybody says it's in the way, you're going to have to move it back, but if those people in the back are okay, you can leave it there. Just,
If it's an obstruction.
it just can't be an obstruction. But if they're not complaining, you can leave it.
Okay. Presentation of a preliminary investigation by Phillips Price Scrigel Lahaney Hughes LLC as to whether the study area known as Block 27, Lot 7, and 791 Holmdel Road qualifies as a condemnation area in need of redevelopment as defined under the Local Redevelopment and Housing Law, LRHL at NJSA 40A:12A.
Okay, before we begin, I'd like to make a brief comment. Isn't it on? Oh, then I'll start
Just
over,
make sure
okay.
there's no conflicts with any of the board members.
Right, are there any conflicts?
Property owner.
No.
Okay. Before beginning, I would like to make a brief statement about tonight's proceeding. Tonight's meeting is strictly and only to determine if Block 27, Lot 7, which is the existing building of the former Nokia Crawford's Hill facility located at 791 Holmdel Road, is in need of redevelopment. We will then convey our recommendations and findings based on the redevelopment report prepared by the planning board's planner to the Township Committee. This is the only action this planning board will make this evening. This report does not include or involve Lot 6 or Lot 6.01, which is the site of the horn. If you are here for the purpose of the horn antenna, we will not be hearing any testimony or taking questions or comments regarding the horn. After all testimony of our planner and board, we will then open the meeting up to the public. The planning board will hear questions first and then hear comments that will be limited to 2 minutes per person. Again, we will not take questions or comments regarding the horn antenna. Thank you. Let's begin.
So I think, as Madam Chair, Special Counsel for the Township just wants to give a quick introductory
Yes.
Hi.
statement.
Thank you.
Full
Hi.
dedication.
Good evening,
Madam Chairman, Chairwoman, and Planning Board members. My name is Andrew Bayer. I'm Special Counsel to the Township, and I was just asked to sort of set the table as to what, as already has been noted, this was referred by the Township Committee to the Board by resolution, starting at Resolution 2022-307, which authorized this Board to conduct a preliminary investigation to determine whether Block 27, Lot 7, and 2 additional lots met the criteria to be determined as a non-condemnation area in need of redevelopment. Then on March 14th of 2023, the committee adopted Resolution 2023-115, which modified Resolution 2022-307 only to the extent that it authorized the study for the same lots and blocks to be considered as a condemnation area in need of redevelopment. Lastly, the committee adopted a resolution 2023-169 on June 13th of this year, modifying the previous resolutions to limit your study to Block 27, Lot 7 only, as noted by the chairperson, and to whether or not that constitutes an area in need of redevelopment for condemnation purposes. And so that is what the Township Committee has asked this Board to do, and that's really, I just wanted the Board to understand sort of the committee's actions before you undertake your study. Thank you.
Thank you. Okay, let's begin. Kate?
Okay, great. Hi, thank
Hi.
you, Chair.
Let's swear you in.
Oh, yes.
Do you swear to tell the whole truth, nothing but the truth, so help you God?
Yes, I do.
For the record. Kate has
Okay.
been sworn in.
Great. Good evening, everybody. Good to see you all. So tonight we're here for the public hearing with regards to this preliminary area in need of redevelopment investigation, which is for only Block 27, Lot 7. So you all have copies. I believe you all should have received copies of this. I recently, we updated the draft to the September date when the hearing date was pushed. So, but it's no other significant changes were made. So I am referring to the document that is draft dated September 2023. So, this is the culmination, and I'm not going to repeat Mr. Bayer, but this is the culmination of a process that began at this Board towards the end of last year. The study area has been tweaked by the Township Committee, it's been refined, and at this point, the study that's before you tonight is consideration of a condemnation area in need of redevelopment, specifically for Block 27, Lot 7, which is the portion of the Crawford Hills Nokia site that contains the building, the main parking area, and certain circulation driveways, as well as the stormwater management basin. So, in preparation for this investigation, my firm, led by myself, undertook a review of a number of township records. We look at the master plan, we look at the zoning ordinance, the underlying zoning for the property. And while this does not necessarily, this does not have an impact on whether it is declared an area in need of redevelopment or not, we can look towards master plan goals, and we can look towards objectives that have been set forth by the township in the past to see how a potential redevelopment designation could fit into that. We also reviewed tax records. We looked at a lot of government records, including deeds, easements, NJDEP, etc. And in addition, we also spoke with township officials, including Steve Winters, just to talk about, the existing, we got development applications, building permits, and code enforcement violations. And finally, we did also contact the police department because we had, in conversation with the representative of the property owner, we had been told that there had been a number of events, minor but criminal events on the site. So I'm going to just briefly go through the remainder of the report. Essentially, the report is divided into 6 chapters. So we're looking at chapter 2. Chapter 2 begins on page 2, and this is really just an identification of the study area, the parcel itself, and its location within the township. As you know, I'm sure this board is well aware, this site was initially utilized as an annex to Bell Laboratories in conjunction with the Hill, which was the highest point. It remains the highest point in Monmouth County. This was really sort of an experimental annex to the main Bell Labs facilities in town, even before what is now Bell Works was constructed. So the building in question was constructed circa 1962. That's when it opened. And to my, as per a review of older records and photographs, it does not appear that any significant changes have been made, at least to the design or the exterior footprint of the building since then. The latest Bell Labs went through a variety of sales beginning in the 1980s, and they kind of spun off from Bell Atlantic and all kinds of things. And finally, the successor companies ended with Nokia. In 2020, Nokia sold the property, which prior to COVID-19, or the time of the start of the pandemic, was very underutilized as compared to its potential, or compared to its maximum in terms of the number of employees on the site. Nokia sold the property to the current property owner, and the building has remained vacant since then. So that's going on almost 3 years at this point, since late 2020. Figure 1 shows the location of the study area, which is just slightly north of where we are sitting right now. This portion of the property measures 8.42 acres, I would note, it represents a smaller part of the overall tract that formerly comprised the Crawford Hill site. And this is visible on Figure 2, which is just the township tax maps. Figure 3 is an aerial photograph, and in the sort of center left, you can see the building in question on Lot 7. Turning to Section 3, starting on page 6, this is just a review of we begin with a review of the current zoning for the site, which is RL40 Research Laboratory District. This district, it essentially permits only public buildings, township-owned buildings, or research laboratories, as well as child care centers, which, per the MLU, are permitted in all non-residential zones. It permits conditional uses such as including wireless telecommunications towers and churches, and has very limited bulk requirements, as you've seen as compared to other zones in the township, namely because of the type of use that was on the site. Maximum permitted building height, for example, is 100 feet, but did require large setbacks, such as 500 feet from any street line. And then we looked also at the master plan treatment of both either this site in particular and also the RL40 district. In 2004, which was the last comprehensive master plan adopted by the township, the recommendation was to re-identify the RL40 district, which did not happen. The recommendation was not implemented. That plan had a series of goals and objectives, some of which I'll highlight below, and many of these have continued through current re-examination reports, which I'll refer to in a moment. Just want to, the goals and objectives that I think are relevant to the review of this area in need of redevelopment investigation include, Goal 2D, to provide for future land uses and development at suitable locations, etc. Goal 3E, facilitate the redevelopment or upgrade of existing non-residential properties where appropriate. Continue to limit clear cutting of woodlands and encourage preservation of trees. And protect natural resources to the greatest extent feasible, including woodlands, surface water, etc. And in this case, we're looking at a site that is almost entire, it's largely developed already. So there's not a greenfield site here. 2010 and 2020 master plan reexamination reports also looked at, both the not the property in particular, but one item that was addressed was the overall decline of industrial and research complexes. This is a trend that, seen not just within the township, but across the state and the country. No specific changes or recommendations were proposed related to that, but this was noted at the time of 2020 reexamination. The report did not recommend specific areas for redevelopment, but left open the possibility to use the tool in appropriate areas in the future. Figure 4 shows the existing zoning and then compared to the residential zoning that surrounds the property. Chapter 4, beginning on page 10, I'm not going to go through this because this is really this lays out the statutory criteria for the establishment of an area in need of redevelopment. And this is taken directly from the state's local redevelopment and housing law. And the governing body of the municipality has to conclude by resolution that the delineated area meets at least one of any of these conditions. And that's what would occur if after this board makes their determination tonight. So for future reference that I'll get to very shortly, the two criteria that we utilized for this site primarily is criteria B, which refers to office buildings that have been vacant for over 2 years, and also criteria A, but I will get into more detail with that shortly. Section 5 really is the description and evaluation of the study area. The study area consists only of this one lot, and we provide an overall description of it and go through a little bit of the site history, which I think is it's a unique property and it's a unique history within the township. So, this site was used for a long time, dating back over 70 something years. Before then, the building was constructed in 1962. We go through a brief description of the Big Bang discovery on the site, which is not, on the larger parcel, which is not part of this site, but it was part of the history. So as this continues on with the current owner's purchase of the study area, as we mentioned, and in conversation with the owner at the time of a site visit, which I did neglect to mention, we did visit the site in March 2023. The owner indicated that they had initially attempted to lease the property to new office tenants. This was unsuccessful, partially because it was due to COVID-19, and also, just the general challenges related to office space. In terms of the site description, as I said, we did visit the property. We went inside the main building. The building, it's a 2-story laboratory, research, and office building. Floor area is approximately 56,600 square feet. The main wing really consists of a central corridor with small offices on the south side and laboratory spaces on the north. Essentially, it was purpose-built for each scientist to kind of have a little office and then a laboratory within the same corridor. So it's a rather unique floor plan in that sense. Another wing of the building in the rear houses a specially clean laboratory, which features the type of equipment for highly sanitized work and is kind of a unique, again, a very unique use within this building. Again, per conversation with the representative of the property owner, the principal building had typically supported around 150 to 200 employees, but at the time of Nokia's sale, the building housed approximately 66 employees, and that's relatively that's also supported by some contemporaneous newspaper articles that I found, basically stating that it had, I believe, 125 to 150 employees at the time of its opening in 1962. I go on to describe the stormwater pond and the landscape easement. This covers the northwesterly portion of the study area. This is the area that's closest to Holmdel Road, and it really consists of undeveloped forest area on steeply sloped land. So this is, it was identified as not suitable for development and then put into a landscape easement, that is held by the township, which remains to this day. Go on to describe the grade changes on the study area, which even though this is sort of the bottom of Crawford Hill, there is still a really notable change from the front to the rear. Per our analysis, basically it rises about 100 or about 80 feet from across the border and then eventually on lot 6, that's when you reach the highest point in Monmouth County, which is not on this parcel. In terms of environmental assessments, we reviewed several remediation records, and there's just some groundwater cleanup and a small area of contamination that is held in an easement by NJDEP. In terms of the crime and security, we did request records from the police department, which did document a number of sort of illegal but categorized as nuisance activities on the site since its closure. We have a narrative form, the incidents that are mentioned here, and really just types of suspected trespassing, vandalizing, and of both the building, inside the building, and the outbuildings. So the property owner, mentioned this to us at the time, which is one of the reasons that we looked into this, and we did find, both upon the site visit and upon police records, that there was some trespassing going on the site. Since then, I know I can't speak for the property owner, but I know that they may have attempted to secure the property since then. I know, but prior to that, this was going on for several years. So code violations, there was a notice of unsafe structures issued in March 2021. There's some outbuildings that kind of just were served as like sheds and kind of storage areas, and that were on this property, as well as some that extended onto the properties that are not in this study area. This is a quote from construction official Steve Winters, who states that the property owner did secure some buildings, but there was concern with the existing main building, which was vacant, and the maintenance of the fire suppression system therein. Work permits were limited to removal of a diesel fuel underground storage tank and demolition of a shed and what's so-called 7-meter satellite dish on the adjacent lot, which is not relevant to this study area. So upon evaluation of all of this information, we look at what we have, and we look at all of the data, and we compare that to the statutory criteria that I mentioned previously, and really look at how this can fit into that. And in this situation, I think the item that I will draw attention to the most is criteria B, which is the discontinuance of the use of a building or buildings previously used for commercial, retail, shopping malls, office parks, manufacturing, industrial purposes, the abandonment of such building or buildings, significant vacancies of such building or buildings for at least 2 consecutive years, or the same being allowed to fall into so great a state of disrepair as to be untenantable. This criteria was added to the statute several years ago, really in response to the challenges associated with vacant and dilapidated retail, industrial, office buildings across the state. So the criteria here is looking at the vacancy of the building. In addition, in our opinion, the property also qualified for met the statutory criteria of under A, which is that the generality of the buildings are substandard, unsafe, unsanitary, dilapidated, or obsolescent, or possess any such characteristics as to be so lacking in light, air, open space, so as to be unconducive to unwholesome living or working conditions. And I will, we'll review this a little more, but essentially, these buildings are not necessarily, this building is not necessarily unsafe or unsanitary, but the obsolescence factor here is why this determination was made. So essentially, I'm not going to, section B, beginning at the bottom of page 17, I'll turn back there. We looked over this information. We looked at changes in the office market, and really, this is an office building that was constructed over 60 years ago to meet the needs of a very specialized user. Essentially, this building was constructed specifically for mid-century telecommunications research. It managed to continue functioning as with sort of remnants of the same company in a less populated state, but at this point, the specialty purpose building is the special purpose of the building is unique. And this is related to the prospect of re-tenanting the office and lab areas. And again, this is based on both conversations with the property owner and my experience and my knowledge of the markets in New Jersey, where re-tenanting office and lab is a challenge. New lab space, it has very specific requirements for air circulation, energy, water use, and it's often very impractical or too costly to retrofit an existing space. The obsolescence of the building and the lack of tenancy resulted in a pattern of crime and deterioration on the site. While these are nuisance crimes, trespassing and vandalism were persistent on the site. The building was open to the elements on our tour of it in certain areas where there were windows that had been broken and other doors that had been smashed. And so that, that's never a good thing for a building that's been sitting vacant. So this is in summary here, there's just a variety of conditions on the property that are really detrimental to the potential health, safety, morals, and welfare of the community, which is part of the statutory criteria. The next paragraph, I mentioned this previously, but again, this was facility intended to serve as a research annex to the larger Bell Labs complex. The building became an outlier in this location as the companies, consolidated, then deconsolidated and decentralized. And, Kia now, has the headquarters in Murray Hill in Berkeley Heights, rather than in Holmdel down the street as it used to be. So the specialty use facility has limited appeal in this marketplace, especially given the lack of similar users in Holmdel at this time. And so, essentially, as a result, this commercial office building has been unoccupied since December 2020, which is for a period of over 2 years, which meets criteria B. And, just in summary, the building has remained vacant for over 3 years, and the land has remained unproductive. So, as such, the designation of the study area as a condemnation area in need of redevelopment would serve a public purpose by returning the property to productive use. And as a result of these conditions, we determined that there is a legitimate basis to declare the study area in its entirety, which is consistent of only the one block, as an area in need of redevelopment in accordance with the A and B criteria. So we just have one last map that shows that, those criteria, and then follow with an appendix. Which I won't go through, but this consists of historic photograph of the building upon its opening, so shortly after its opening in 1964, and photographs that I and my colleague took on the site on March 16th, 2023. So I open this to the board for any questions as to, the contents of the report or the procedure.
Okay. Anybody have any questions? John?
Kate, the work order that was issued in May of 2022 for the removal of the underground diesel tank, was that completed?
Hold on one second, sorry.
Basically, is the diesel tank still there?
No, that was 1999.
What was the work order from May of 2022?
Demolish a utility shed and a satellite dish.
There was mention of a 1,000-gallon diesel tank?
Yes.
Is that still there?
My understanding is no, because that's a permit from July 1999. And it was not still open.
The environmental concerns that you listed, was it limited to just the former septic leach field / septic tank?
That's the primary item. There was also a what NJDEP refers to as a area of deed notice. This was related to a remedial action. I have to admit that I don't know exactly what that remedial action was, but that was concentrated in a small area of the property, which would have to be remediated again for certain types of future development. There was also an evaluation of certain compounds that's listed in the paragraph right above the easements and encumbrances section for concentrations of compounds that are listed there, and that would the report that we reviewed, which was provided by the property owner, stated that any redevelopment or any new actions would require potential remediation or protection measures. So it's a little
In your
more than
opinion,
just septic.
if it is limited to that septic leach field area, which you said is concentrated,
Yeah.
with a 60-year-old building and septic tank, is that a big number to rectify or remediate that septic tank, in your opinion? Because I don't know anything about septic.
I don't know. I don't know. In my opinion, the environmental conditions on the site would not be enough to rise to the level independently of declaring it an area in need of redevelopment. But in the context of the site, particularly its vacancy, that does play a role in its current status. But yes, I cannot answer that, unfortunately.
Ron? Yeah.
Yeah, just
Scott?
so I'm clear, if something is designated as an area of need of redevelopment, that doesn't mean they have carte blanche, right, to do.
If this board chooses to, make this recommendation to the township committee, and the township committee chooses to adopt this designation by resolution, nothing changes on the property. No zoning change. The zoning doesn't change. There's no change to the permitted land uses there. That would only occur if the township committee decided to move forward with a redevelopment plan for the property, which would function the same way that a land use ordinance does, in which, it would be prepared, it would come to this board for master plan consistency review, and then adopted as an ordinance. But at this, just the designation of an area in need of redevelopment does not change anything.
So what's the difference between them just doing what they need to do to fix their building versus calling it an area of need of redevelopment?
It does provide you later with the option of a redevelopment plan. But where the redevelopment plan can be, it can be tailored to a specific property or properties, but that's the next step of this process. You can't have a redevelopment plan without declaring it an area in need of redevelopment. That's essentially the benefit.
I don't know if this is a question for Kate or Andrew. Can you please confirm, if we make a recommendation for or against, the township committee does not have to abide by our recommendation? Is that correct?
Do they need us?
So that's a legal, I don't know, Marty, if that's you or me, but because you're
Yeah.
board.
You can, we can make any recommendation, and the township, has its ability to do what it wants, but they're going to listen to our recommendation. They're going to have a hard time not listening to our recommendation, I guess is my unofficial special counsel answer, but Andy, if you want to give a more detailed special counsel answer.
The committee would certainly have to take into account a recommendation of the board.
But they can disregard it as well.
Well, that would be an interesting legal question. I
So-
have not encountered that.
So if we do approve it, it opens it up for potential redevelopment. You said nothing changes. So there is the potential for redevelopment, given the township proceeds. But if we do not approve it, that takes any kind of development off the table. Is that correct?
No, no, any underlying zoning still applies.
RL 40, in the RL 40 zone, correct? Which is research labs.
Yes.
Okay.
And I would just clarify, Mr. Emma, you're not, the board doesn't approve or disapprove.
No, it's just a recommendation,
The
correct?
board makes
I understand.
it's been referred to you, to refer to the board for a preliminary investigation to determine whether or not, or make a recommendation to the committee whether or not it meets the statutory criteria.
One quick question. I remember reading about an easement on the property. I remember reading about an easement
Yes.
on the property. Can you just?
Sure.
tell me about it?
If you-
I've been looking.
Landscape easement?
Yes, if you look on page
I
16,
couldn't
we
find
discuss
it.
it. There is a
put
township-held
it-
landscape easement on the steep slope portion of the property along Holmdel Road. This easement also extends onto the neighboring properties, but it covers only a portion of this property.
Okay.
And
so it
that's
does
held by the
run through.
township.
Okay.
So there's no, is there any con or any negative to designating this area in need of redevelopment?
That's not really, can't really, I'm trying to think of how to answer that. This is something that the township committee determined was in the best interest of the township and decided to pursue it as such. So that's, and this is a report that reflects that. And in our professional opinion, this does meet the statutory criteria.
Okay.
I have some questions too.
Okay.
Go ahead, Wes.
Specifically regarding the area in need of redevelopment. Then we have a little suffix that talks about condemnation. Are these two different subjects in the same arena?
They, areas in need of redevelopment may be identified as condemnation in which the township reserves the power to acquire the property via eminent domain, or non-condemnation. The township committee determined to go forward with this as a condemnation area in need of redevelopment. However, it has no bearing on the investigation or the determination of whether it meets the criteria. There's no special criteria that has to be met for condemnation. It just has to be, publicly noticed and publicly stated in all of the material that it is being pursued as such.
So the initial inquiry of the Township Committee to the Planning Board was, do I understand that was revised to include the word condemnation?
No.
Yes.
Yeah.
And then it was further revised to limit the study area to just the single lot.
Single lot, area need of redevelopment, along with condemnation possibility.
Yeah, I would also note that however it would determine to go forward, the township is not required to utilize their condemnation powers, even if it is declared as such.
In the pages 15 and 16, where you talk about soil contamination and the PFAS, if the building were removed, that really doesn't affect any of the contamination on the site, right? That still remains?
That's my understanding from the report that that's what we were provided. I can't answer further than that. Not my area of expertise.
One of the reports talked about building management being in the process of boarding up or tearing down outbuildings. Any of those buildings on this lot?
Per the notice of unsafe structures, some were on this lot at the time, with broken windows, doors, walls, and roofs. I don't know the status of any of the individual outbuildings.
Just in talking about the statutory criteria, where we talk about both A and B, it seems like it was almost written for this building, right? The building just about meets everything talked about in A. On the other hand, it seems to establish a very low bar for seeing something of this nature.
I mean, the criteria is the criteria. I will say, there's been a number of court decisions over the years that have narrowed the scope of certain criteria. Most recently there was a specification given to narrow the how criteria D might be utilized, in which you have to really show that it had a you had to actively demonstrate that there was a detriment to the health, safety, morals, or welfare of the community. So the statutory criteria read it is what it is, but it's not necessarily, it's not, I wouldn't call it objective.
And the result of your study and the result of our recommendation, in no case does it talk about what should be done with the property.
Absolutely not. Absolutely not.
That's it. Thank you.
Yeah, again. So look, if this is statutory, it's really a legal thing, no, Marty? If the rules are the rules and it complies and it meets the definition in the rules and the laws, what's there really to discuss?
Well, the finding, you're obligated to make that decision. It's not, I don't make that decision for you. That decision is with the board, and obviously not me or Andy.
Right.
But, you have to determine whether, as Kate said, does her facts and presentation meet A and or B?
Right.
That's all you're really looking at.
Right.
Does it meet the criteria? Like that's what
Right, if it meets the criteria.
we
it's,
normally do, right?
Right.
Correct.
I mean,
Exactly.
That's our job.
That's your job.
Right.
Does it meet that criteria or not?
Yes, that's right.
And similar to the, in that vein, this is our report that we prepared as professional planners. So, similar to how you might hear testimony, it's part of your evaluation of the task at hand.
Right, and you've inspected the property, and
Yes.
you've said, in your professional opinion, you feel that it is substandard, unsafe, and meets the criteria of A and B, right?
Unsafe might be a little. I might not use that one in particular, but I would say substandard and obsolescent.
Right.
And it absolutely meets the criteria of B, in which it has been vacant for 2 consecutive years.
As you know, the town has entered into negotiations with the owner for 6.0 and 6.01. We're only talking about 7 today.
Yes.
They're in discussions because if those discussions are not successful, they're going to proceed with eminent domain for those 2 parcels. Is any recommendation that we make tonight have any effect on the Township Committee's ability to include 7.0 in eminent domain if it ever comes to that?
It would be anything that would be done, and I'll defer to the attorney just on this also, but anything that would be done with regards to this property, if if a recommendation was put forth, would be completely separate action from what's currently underway.
So our recommendation will have no effect whatsoever on the Township Committee's ability to do what they might want to do with 7 in regards to eminent domain. Because my question is, I just have a question, why wasn't this parcel included with the other 2? So leads me to believe there clearly could be potential for redevelopment, and that's what I'm trying to get at. Could this be included as part of an eminent domain action later on?
Yes, that's the township reserves the right by declaring it a condemnation area in need of redevelopment.
But that would have nothing to do with our recommendation here tonight.
I mean,
The right to include Lot 7 in an eminent domain action will not be handicapped by our recommendation one way or other tonight.
You're just just saying if it meets the you're just going to determine if it meets the criteria.
Yeah.
At that point, it's going back to the town, and the township committee will decide, does it want to condemn, does it not? Does it want to enter negotiations for this lot or all lots, or what? It has, its hands are still open at that point. I mean, Andy can chime in if I'm saying something wrong, but all we're doing today is saying, township, if you want, you have the ability, this property meets that criteria. It's now back in your court.
And
You decide.
And the local housing and redevelopment law, through the condemnation area need of redevelopment process, provides a channel for potential eminent domain takings of a property. However, it's a different procedural action than what the township committee is currently involved in, and I can't speak to how it would, have any future impact.
All right, so then, oh, sorry.
Okay.
So then basically that this could be an immaculate building, and just because it's vacant for 2 years, it's automatically declared.
I don't know if I would want to be the planner who made that case,
But
but
that's the way it reads, no?
No.
No, it says or,
yeah,
so it says or. So anyone just could vacate a building for 2 years, and then they'd automatically can get redevelopment? That's the way the law's written?
If that municipality was willing to go down that route and have a professional
Yeah.
planner make those conclusions.
All right, but isn't that what it says? Am I wrong? It's the plain reading of it. I'm no lawyer, but plain reading of it says that qualifies for that one premise alone. Yeah, okay, just to make sure I understood that. Yeah.
All right, I think your reading is not incorrect.
right.
But, if there's a brand-new shopping center that just hasn't got a tenant yet, I'm assuming the township's not going to want to go down that path.
Right.
Yeah, but
Okay.
then
It's not
what we
automatic.
then-
But it's not for us to decide.
Right. It's
Yeah.
look, it's no different than someone has a house and they want to build a skating rink next to the house and they attach it with one wall, and they go, they
Yeah,
pass
but
it.
because it's been vacant for 2 years, it is substandard, unsafe, unsanitary, dilapidated, it goes on, because that's where the other criteria
Right.
is met.
Right, but I'm saying that even if you ignore that, just B, you just have to
But we're not
comply
also-
with
okay.
one
The-
section,
the,
right?
the only other
Right.
legal comment I would make is that this is the term is colloquially known as blighting a property. So I think, as the board attorney noted, if it was a newly constructed strip mall that didn't have tenants for 2 years, it would be not, I don't know if that kind of conclusion that you're blighting that property would be upheld, but that is a plain reading of
Yeah.
the statute.
Yeah, I agree, and I would also add, that it's up to a municipality to decide what to do, and also, as a professional planner, we would have to give an expert opinion on it, so it's not just an automatic anything, but yes, I think that what Andy said was very helpful.
But I think item A reinforces item B.
Oh, yeah, I mean, look,
As
you
far as
could, you
redevelopment.
can qualify with all 6 of them.
True.
I'm just saying that the way the rule reads, the law, it's statutory, it's a law. It's not a suggestion, right? So sometimes I can get concerned, can I tell someone that they can't do what's plainly written in the law? Yeah.
Any other board members have any questions for Kate? Anybody? Okay, we're going to take a 10-minute recess, please. Wes, can you please turn off the...
Yep, yep.
Okay.
Are there any other questions from our board members? Kate?
Yeah, I just want to reiterate, Kate, you said that it's still zoned the same use, the same everything. That doesn't change from our perspective. It's just,
If the board determines, that this, to make the recommendation to the township committee, the township committee adopts by resolution, declaring this an area in need of redevelopment, nothing has changed.
okay. So make sure, okay.
There's a whole procedure set in place by the local redevelopment and housing law that
Okay.
is after this.
Okay, I'm going to open up this portion of the meeting to the public for questions.
He's part of the public. Oh, we will recognize him first.
Yes.
Does he get 2 minutes?
So
Sir.
we have counsel for the property owner.
Yes.
Can you please state your name and spell it?
Is this?
Is it red?
Yeah.
Okay. Hello.
Oh, hi, Ms. Chairperson, members of the board, Mr. Fledger. My name is Joseph Grather. I'm with the law firm of McCurdy, Riskin, Olson, and Delapel, and I represent Crawford Hill Holding LLC, which is the owner of the property that is the subject of this study investigation.
Can you swear him in?
No, he's just the
Oh, that's right.
attorney. We're in the, just questions, do you have any experts or any witnesses that you also want to present?
With the board's indulgence, I would like to ask a few questions of the township planner, and then I have brought with me a planner myself and an architect, and my client may testify also. I have provided.
So we'll do the questions first of council, then I think the public should have its chance to ask questions to get the questions out of the way.
Okay.
Then we'll go back to Mr. Grather
And his planner and his professional.
I had provided counsel for the board a copy of the sealed and signed report, which
It was given to the planner and to Mr. Bear, so if you have any other copies, we have not seen it.
We don't,
should I do that when he testifies, or?
You can do it now if you have them ready, yeah, that'd be great. So while he's doing that, just for the record, so while we did ask for this report, it's not required, but we asked for it ahead of time. We're just getting it now, so we're kind of going to be going through it a little bit. You may not have a very smooth response when there's questions of the report, because we may need to look at it and/or possibly adjourn if that comes to that. I don't think we do, but it's possible.
It looks kind of thick.
So I'm going to hand
Yeah,
it,
you can come up.
read it
so I
for me.
provided,
That's
Read
no
it for
pamphlet.
Should this be
What
is
the report?
We haven't seen it.
We don't
It's
know.
an objector's planner report.
should this be admitted as a or O?
Yeah, yes. We'll wait till his expert gets up, but this will be an exhibit.
It's a September 5th, 2023 report by Steck Planning Consulting, Peter G. Steck, Community Planning Consultant. Which,
Yeah, any extras for the public, if anybody wants to? You're gonna have to share those, I think, so.
Is it online?
it is not online.
Okay. Would you like to begin, sir?
Yes, thank you, Ms. Chairperson.
Will the public be allowed to ask questions about this report?
Yes, we're gonna do questions first of Ms. Keller's report from the attorney first, then the public. Then we'll let the attorney present his case if he has one for his planner, and then you can, obviously, anybody can question that report as well. Good. Mr. Rather.
Hi, Ms. Keller. My name is Joe Grather. I represent the property owner, as you just heard, and I have a few questions about your report.
Sure.
The first question I have is, I was provided a copy of an August 2023 report by counsel for special counsel, and the report that was provided with a copy today is dated September 2023, and the basic question is there anything different besides the date?
The date was updated to reflect the date of this hearing, and there was one typo corrected on the last page of the main report. There's no other significant changes.
The substance of the report has not changed from August to September?
There's not even no substance. There are no other changes at all.
They're both 29 pages. They're both essentially...
Yes.
Okay.
The content is the same.
Thank you very much. Ms. Keller, is it your opinion that the study area property is a blighted area?
Under the provisions set forth in the local redevelopment and housing law, particularly criteria B, yes.
And it's your understanding that the public use and public purpose authorized by the condemnation to take private property is that the property must be a blighted area, right?
Yes, it's stated in the New Jersey Constitution.
And that's the authorization for the local redevelopment and housing law, right?
Mm-hmm.
Were you first retained when the governing body transmitted the authorized and directed the planning board to study for non-condemnation purposes Lot 6, Lot 6.01, and Lot 7?
Yes, I served as the planning board planner last year and this year as well.
So did you commence a study report in response to that direction and authorization?
Yes.
Is it contained within the September 2023 report?
No, the report was significantly, it was never, internally, we made significant revisions to the report before, when the changes were made to declare a condemnation area first, and then more importantly, to reduce the lot area to just this one lot.
Is it fair to say you never completed the initial study?
No, we did not.
Is there a reason why this study is marked draft and not signed?
Yes, because this is a public hearing and it's an opportunity for the public and members of the board to make comments on this study. For example, the board could and has, in situations I've been in the past, the board can request a change be made, etc., something be added, something be subtracted, and then when it goes to the township committee, that's when it would be a final version signed and sealed. This is, in my opinion, it's a public hearing, and it's still in draft form.
You inspected the property with one of the representatives of the owner on March 23rd, 2023?
I believe it was March 16th. Was it the 23rd?
Interior.
March 16th, I think
Okay.
you're right.
I went off the dates on the photos. So yes, I did.
Yeah, on page 1 it says March 16th, 2023?
Yes.
That was the date. I believe you testified in your direct that you're familiar with the Malanga versus Township of West Orange case?
Yes.
And that was decided by the New Jersey Supreme Court on March 13th, 2023?
Yes.
And that case overturned a blight designation by the Township of West Orange that had relied upon a finding by the board that a property had been detrimental to the welfare of the community. Is that right?
With specific regard to the D criteria as set forth in the MLUL, yes.
The court specifically held that when you're employing the D criteria, there has to be evidence of a detrimental effect on the public health, safety, welfare, or morals of the community. Isn't that true?
That is what the court decision stated, yes.
And the court emphasized that by saying you have to have evidence of actual harm caused by the blight influence, correct?
With regard to criteria D, yes.
So it's and it's your opinion that the blight condition is satisfied by criteria A and criteria B, right?
Yes, particularly criteria B, but yeah, yes.
So you examined all the criteria within the statute, which are reproduced in your report on pages 10 and 11, and you came to the opinion that only A or B applied, right?
Only one is necessary for designation. I determined as part of my investigation that A and B were applicable in this situation.
Specifically with respect to criteria A, you relied upon the fact that your allegation that the building is obsolescent?
Yes.
In addition to being obsolescent under criteria A, the obsolescence has to be conducive to unwholesome living or working conditions, right?
Yes.
So you can't just determine that a building is obsolescent in order to determine it's in need of redevelopment, right?
Not under criteria A, no. In this case, this is a building that it's in bad shape right now, and in my opinion, that would result in unwholesome working conditions.
Okay, and in reviewing the Malanga opinion, the court, in interpreting this statute, relied upon dictionary definitions of all the terms set forth in criteria D, right?
Yes.
Unwholesome is defined in the dictionary as detrimental to physical, mental, or moral well-being, unhealthy, marked by lack of integrity or dependability, corrupt, unsound, offensive to the senses, loathsome, and repulsive. That's Webster's Third New International Dictionary at page 2525. So your opinion is that this building is conducive to unwholesome working conditions, right?
I did not catch every dictionary definition that you mentioned there, but based on that, unwholesome is a term with broad meaning in my opinion, for criteria A. But again, only one criteria, in this case criteria B, would be necessary to designate this property as an area in need of redevelopment.
I appreciate that, and we'll get to criteria B in a moment. I just want to understand your opinion concerning criteria A. Do you disagree with my definition of unwholesome?
Again, I didn't catch all of it. Would you care to repeat it?
Sure. It sounds a lot like...
Mr. Grather, you're reading the definition from the dictionary. There's no court that reported that as their holding, so we can talk about your dictionary meaning all day long, but I'm not sure Kate's here to answer whether she thinks that everything in that definition would be upheld or not upheld by a court. So my 2 cents is, you asked the question, you got an answer. I think we should move to the next question.
Fine with me.
The Supreme Court of New Jersey in Malanga versus Township of West Orange said, I quote, "The adjective detrimental means causing harm, damage, or loss, injurious or hurtful." Black's Law Dictionary, page 565. Continuing the quote, "As discussed above, NJSA 48:12A-5D requires a showing of actual harm. It cannot be presumed," end quote. That's on the slip-up opinion at page 40 of the New Jersey Supreme Court. And the witness testified that she was familiar with the Supreme Court's use of the definition of detriment in reversing a blight designation. I think it's highly appropriate for this planner to support her opinion that this building is conducive to unwholesome working conditions by employing a definition of unwholesome that's set forth in the dictionary.
Well, again, we don't have the benefit of your report or time to review a dictionary, but if she's willing to answer that, she can. I believe the question was already answered. But Kate, I'll defer to you if you think you can add any more to it.
Sure. I would just note that the decision that is being referenced here was specifically in reference to criteria D, which has not been utilized as a means of designation in this report. So just want to make that clear, that these questions, are maybe based on that decision, but in my opinion, it's not relevant.
Is there any evidence set forth in your report that this building, this property is detrimental to the health, safety, welfare, or morals of the community of Holmdel Township?
I believe that language was used in here, but it was not used in furtherance of a criteria D designation. On the top of page 18, we reference the fact that there is obsolescence and lack of tenancy, deterioration on the site, deterioration of the building, as well as contamination, steep slopes, and existing encumbrances presenting challenge to development. There's a statement that this is detrimental to health, safety, morals, and welfare of the community, which I would note is a phrase that is used frequently in the planning field. It's part of the goals of zoning, part of the municipal land use law, and in this case, it was not used in reference to the criteria D.
Okay. You stated at the top of page 18, this obsolescence has resulted in a pattern of crime, right? This obsolescence and lack of tenancy. Has resulted in a pattern of crime, right?
Yes, as I described during my presentation earlier, these are, while they may be called nuisance crimes, the vacant property did attract a pattern.
Are there any pending criminal cases arising out of the crimes occurring at this property?
I am not aware.
Has the Monmouth County prosecutor prosecuted any cases arising out of these crimes?
I don't know.
Has the Holmdel Township prosecutor opened up any criminal actions for actions emanating out of this property?
I don't know.
The lack of tenancy caused the crime?
Vacant properties, vacant properties, the vacancy of this property in particular, and this is also, I would note, was in response to the statements made by the property owner at the time of our site visit and previously, that there was a pattern of vandalism and crime.
The police reports the police incident reports that you cite to in your report, the most recent one is from August of 2022, right?
Mm-hmm.
Is there any evidence of current issues with the police?
I am not aware, but I have not requested records since earlier this year.
Are there any instances of health code violations emanating out of this property?
There are not health code violations, but there have been building code violations.
The building code violation that you mentioned on page 17 at the top, issued March 17th, 2021, right?
Mm-hmm. Yes.
Did you obtain a copy of the notice of unsafe structure?
Yes.
Does it pertain mostly to the structures on Lot 6?
It's some of the structures per my reading were on Lot 7. I don't have it in front of me right now to confirm, but that's how it was read.
Mr. Winters confirmed with my client that permit had been closed and the problem had been abated. Isn't that true?
I was not aware of that, but that I believe that sounds true.
It's not an open code violation, right?
No.
Are there any open code violations against this property?
Not to my knowledge, but I have not requested records since earlier this year.
You could say so.
The steep slopes and the environmental condition do not relate to criteria A or criteria B, right?
No.
There is a criteria that talks about topography and the condition of soil, isn't there?
Yes, there is.
That's criteria C, right?
Yes, nature of soil, topography, and it refers also to unimproved vacant land that has been vacant for 10 years. That was not one of the criteria that utilized in this report.
Well, it clearly doesn't meet meet the definition of criteria C, right?
No, no.
So with respect to so by the way, going back to A, did you make any finding? This property's not lacking in light, air, or space, is it?
No.
The building is well lit. I think every office has a window, right?
I can't say to that.
It's a glass building, right?
That is not one of the requirements of that criteria.
No, it talks about air, light, and space.
Well,
That is a requirement of this.
It is one of. It's not. Yeah.
You did not make any findings that were adverse to the property concerning air, light, or space, right?
No.
So with respect to criteria B, as Mr. Silberman astutely pointed out, you can blight this property solely based upon it being vacant for 2 years? Is that your opinion?
That is a direct reading of the statute. As a professional planner, I would look at every situation individually.
Okay, so looking at this situation individually, section,
Sir, I think the report basically lays out what her thoughts are. I mean, it's pretty clear from here. We're going over things that are not based on the criteria she's mentioning, A and B. You're talking about C and D and E and F and G, which she's not relying on for her opinion. So I think if you focused more on A and B, which is what we're looking at, that would be more efficient.
okay. Under the consideration of redevelopment area designation, the planner wrote and spoke about steep slopes and environmental conditions, which she just admitted have no bearing whatsoever on the redevelopment criteria. So I'm trying to find out.
And in her conclusion, it doesn't say that she is relying on those for her decision. So that's why
I'm trying to understand the basis of her opinion.
Sure.
And I was just about to get to criteria B.
I will let you ask your next question.
Office buildings are not permitted in this zone, are they?
Per the letter of the zone, no.
This is not an office building.
No. It's a laboratory building with office facilities, which would be permitted today as well.
It's not a retail building.
No.
It's not a shopping mall.
No.
It's not an office park.
No.
It's not a manufacturing or industrial building.
I would argue that it could be qualified as an industrial building.
Do you have any basis to argue that?
My professional experience and the knowledge of laboratory facilities, including the history of this site dating back to the 1960s.
Does the zoning ordinance say manufacturing industrial?
It does not.
So arguably, criteria B doesn't apply if you read the statute as it's written, right?
I disagree with that. I think that the terms like industrial, terms like office can apply to, especially industrial, can apply to a wide variety of uses and that have not, and it's I think it's unlikely or unrealistic to expect it to cover every single potential use.
Well, there's a very detailed list of uses contained in the statute, is there not?
Yes. I would also note that this property is a commercial property. It was used for commercial purposes. If you're going to take the commercial at its face value, the term commercial.
So any commercial building that's been vacant for 2 consecutive years can be blighted under this statute?
In a straight reading of the statutory criteria, yes.
Excuse me, wasn't that question answered when Mr. Silberman asked that of Ms.
Yes.
Keller? So can we move on and not repeat?
There's no requirement whatsoever that this board find that the building has fallen into so great a state of disrepair as to be untenantable.
No.
And it's
does untenable mean? You can't have tenants, right? I'm not trying to be a smart aleck. Untenable means you can't have the tenants in there right now?
Yes, I mean, I don't have
So we,
the dictionary to answer.
I did, Scott, I would just say I did not evaluate it under that criteria, under that clause of that criteria.
I just asked because would anyone put their, I haven't seen the space, but would anyone put their offices in there now for their staff to work there if it, in the current condition, would it be tenable?
You state on page 5 of your report, if the present conditions continue, it would have a negative impact on Holmdel's tax base to the detriment of the public health, safety, and general welfare of Holmdel Township and its residents, right?
Page
5.
18?
Oh, I'm sorry, page 18.
Yes.
Yeah, page 18.
Yes, I do state that.
Are there any tax arrearages?
There are not.
And the property's assessed at approximately, it's in your report, $3.2 million?
It is as of now.
And that's based upon the Holmdel Township assessor allocating their share of the tax burden, right?
Yes.
So it's not having a negative impact on the Holmdel's tax base whatsoever, is it?
I can't confirm whether whether it would be taxed differently if it were occupied at this time. I don't have no knowledge of that.
Do you have any evidence of this building causing actual harm to any individual?
No, and I do not state as such in the in this report.
Are all of the facts and opinions set forth in your report? Are all of your facts and opinions set forth in the September 2023 report?
With regards to this property and the results of our analysis, yes.
Thank you, Ms. Chairperson.
Okay. Okay, at this point, I'd like to open it up for any questions from the audience. Mr. Blumenthal? Please state your name and your address.
Ralph Blumenthal, 41 Stony Brook Road, Holmdel.
Yes.
Just, did it get, I have to keep it that way.
Have to hold it close.
It's a question, so not so much to clarify something here. For Kate, with regard to the existing zoning, and referring to the report that just, there are a handful of copies on page 12.
Okay, I have not had the chance
I know
to
that,
deeply review this
but
report, but yes.
This is
Yep.
an error that's been out there that I think needs to be corrected.
Okay.
And it describes how they've attempted to market the property, in particular the building, for other uses. And near the bottom, there's an indented set of what is permitted in the R40 zone. And this is based on an email from Lonnie, our zoning officer, which I've seen. The third item in that list says manufacturing of above products would be permitted. I believe that's incorrect, but I think if you go back to the actual zoning ordinance, it's only fabrication associated with the research, not for manufacturing for otherwise sale.
Yes, if for example, you know, what's often called pilot plants, in which is when in a research development facility, there's a small manufacturing facility where they just really test products out. That is the type of thing that the existing zoning contemplates. Fabrication incidental thereto. Manufacturing products that would then go to the marketplace, in my opinion, is not part of the RL40 zone.
Okay, and that's been a confusing point, and I think if they're considering potential purchasers or use of the property, it should be clear what is or isn't permitted under current zoning. Zoning can always change, the township committee can do that.
Ralph, the comments will come later.
Right. We
Fine,
need to
okay, I just want to
clarify.
get that one point clarified at this point, and we'll get the comments then.
Thank you,
Yeah,
Ralph.
Thank you.
Are there any other questions for Kate? Please.
Roberta Kaufman, 13 Chestnut Ridge Road. This building was designed in 59, perhaps, to be built in 62, as was the main building, the main Bell Labs building, designed in 58, 59, and construction started in 61 all the way through to 63, 64, and I'm not talking about the 1983 expansion. We have found a use for much of that area. This building is consistent, most likely was built with similar materials. We have the demountable partitions that make those small, non-bearing wall, that make those small offices that could be enlarged. We have the small offices, the corridors, and the large laboratory space. So the question I really ask is, why is this building being declared obsolete when we can see that the main building is now functional? It obviously needs repair. I mean, I haven't been in there in 20 years. I was in the facility department of Bell Labs from 1985 to 95. I'm familiar with the construction methods. Why is this building, if the main building is not obsolete, why is the laboratory and office space in this building obsolete?
When you say the main building, are you referring to the what's now Bell Works?
What is now Bell Works? What we
The yes.
Crawford Corner facility,
Yes.
101 Crawford Corners Road.
Sure.
Yes.
So just a couple questions were in there. I would say that in terms of building materials, and I can't speak to the exact materials that were used, but in my research of, contemporary news reporting and reports at the time and vice versa, and follow-ups, this building was really intended to serve a different purpose than the main building. Despite, even when you take aside the different types of architecture and obviously the scale of that building, this was intended as specifically to accommodate lab work and only lab work.
But if, what you're saying is it's the size of the building, because every one of the corridors up to corridor G in the main building, so I'm talking about two-thirds of the main building, was designed with large laboratories on one side, corridors, and small offices with interchangeable walls on the other side. So that I see a tremendous similarity, and that is what I'm asking you.
So,
I can't.
Sorry, I'll just chime in a minute too for Ms. Kaufman. So you have to remember that building was declared an area in need of redevelopment. And there was a whole redevelopment plan that was proposed for it. So what they do there now they could not do under the zoning at the time. So the zoning changed.
Right, but not the upper floors are still essentially being used.
The main
as
building being,
office labs.
but it's permitted under the redevelopment plan, right? Those uses in there, many of them were not permitted,
Yeah,
including
of
all the
course.
outside
But
uses.
a good portion of the upper floors are being used that fashion.
That I don't know.
Thank you.
Are there any other questions?
Patrick Trisquita, 56 Line Road. Just a point of clarification on when the building became vacant. In March of 2020, Nokia went to all at home.
Okay.
Virtual.
Remote work because of the COVID. So you did say December of when the purchasers bought it, but actually Nokia was in virtual mode since March of 2020.
Okay. I appreciate that. I may have thought that there were, some people still in the facility, but I appreciate the clarification.
Is there any other questions for our planner?
May I ask a second question, but I promise brief.
Okay.
I promise.
Okay,
Is it necessary for you to recommend and the township committee to accept this is an area in need of redevelopment for them to spot zone this property?
If it were declared an area in need of redevelopment, it would be eligible for the preparation of a redevelopment plan in accordance with the local redevelopment and housing law.
Right, and if it was not declared an area in need of redevelopment, then the rezoning of this one lot could not take place because it would be spot zoning?
I have not done that analysis and can't answer that.
did you have a question, sir? No? Are there any other questions? Then I'm going to close the portion of this meeting. A question? Yes, my part. All right, do you have a witness that you'd like to bring up?
I would.
Okay.
To sit here, or?
Yes, he's more than welcome to sit here.
Use the mic.
Go, use the microphone. We have to swear him in
I have,
and qualify him.
so this is part of that, but I have an individual.
This is, what is that?
Just tell us what
Tell him, yes.
is this qualifications. I handed that.
Okay. Where is it?
So what, the first thing we're going to do is, we're going to mark this report as 01. Just, you did already? So we have something.
Where is it?
I would, since he handed it out as 02.
You talking about a CV?
No,
He's not- That's not in the report? Okay, so we'll go over that when we finish this procedure.
Okay, okay, what's this?
Oh, yes, I'm sorry. I was taking up so much space as an engineer here.
Okay, so this is the architect.
Thank you.
They're going to swear you in.
Okay,
Okay, are you ready?
yes.
Okay. You swear to tell the whole truth, nothing but the truth, so help you God?
I do.
If you please spell your full name for the record.
My name is Andrew F. Trocchia, Trocchia.
Okay, and can you give some background on your
Sure.
story?
I am a licensed architect in the state of New Jersey since 1989. I have a Bachelor's of Architecture from NJIT. My license is current. Started my firm in 1991, and we relocated our offices to Holmdel in August of 2001. We're a general practice firm, private commercial, multifamily, and public projects, as well as feasibility studies relating to repurposing of existing facilities. I've appeared before many municipal planning boards and zoning boards in the state of New Jersey, including Holmdel several years ago, Hazlet, Freehold, Union Beach, Keensburg, Red Bank, Atlantic Highlands, South Plainfield, Carteret, Mount Arlington, and I have never not been accepted as an expert.
Okay. Everybody accept him? No, I'm not gonna. Everybody accept him? Okay, you may proceed.
Okay. Good evening.
Thank you.
I was
Why don't you tell the board what you did, how you got involved in this property, and just go from there.
I was contacted by Rakesh Antala of Crawford Holdings, Hill Holdings, and was retained to observe the conditions of 791 Holmdel Road and to assist with these proceedings. I visited the site on August 22nd, 2023, and met with Mr. Antala, as well as Mr. Paul Fick, who is the property manager, and was given a tour of the facility. I observed the spaces contained within the lower level, including the mechanical room, the second floor spaces, as well as the roof, and I walked the exterior perimeter of the building. Subsequent to that visit, I was provided with and reviewed documents including facility floor plans, an inspection report prepared by Burke Fire dated June 16th, 2022, a document with an offer to purchase the property dated March 28, 2023, and a report prepared by Kate Keller and Spock Trahan from Phillips, Price, Greigel, Lenahy, Hughes, titled Area in Need of Redevelopment Investigation, dated August 2023. Based upon my... Go ahead. Based on my site visit and review of the documents prepared, correspondence that I think you've all been provided with, it's a...
So the board has what's been marked O2, which is a August 28, 2023 letter?
Yes.
Okay. So you prepared that letter?
Yes, I did.
Why don't you tell us about it?
The site, it's a beautiful site. It's surrounded by trees and grass, parking, sufficient parking in the front and the rear of the building, as well as delivery access to the rear of the building. The overall site functions at anticipated vehicle and pedestrian traffic and allows the building to function for an intended use. We observed the exterior finish of the building. It's a metal panel system with bands of glass, and the wing to the rear of the structure is a masonry structure with punched window penetrations. We're up on the roof. The roof is in very good condition. The building envelope appears to be watertight and does not suffer from any forms of obsolescence or design flaws. Building structure is a steel frame and concrete masonry building. Virtually all of the interior walls are non-bearing interior partitions. Facility contains laboratories, offices, conference rooms, clean room spaces, as well as staff and building support areas. There are 3 interior stairs and 1 exterior stair providing building access and egress. Centrally located elevator provides access between the first and second floor, and there are multi-fixture restrooms, restrooms on each level. Ceilings are 10 foot high throughout the building, with nearly 4 feet of space provided above the ceilings for routing of conduits, pipes, ductwork related to the building systems. The floor and wall ceiling finishes are in good condition. The windows provide ample natural light in all demised workspaces. Interior layout functioned as intended for the prior users, Bell Labs, Nokia. There's nothing inherently wrong with the design of the layout of the building that would prevent a user from utilizing the building for the uses allowed by this zone: research and development laboratories and light manufacturing. In fact, review of the provided documents indicated that an offer was made on the property in March of 2023 from a potential buyer for use as a light manufacturing facility. The building is connected to municipal water and sewer, as well as gas and electric utility service. Inspection reports from Burke Fire, dated June 16, 2022, indicate that the standpipe, wet pipe fire sprinkler system, and fire hydrant are all satisfactory. Lastly, in conversations with the property manager, it is my understanding that the existing boilers, chiller, and emergency generator are all in working condition. Therefore, based upon my observations of the existing conditions, the review of the materials provided, it's my professional opinion and belief that the facility is structurally sound and retrofitting for reuse is achievable and feasible. I did not observe any physical conditions in the building or workspace that would support a finding or an opinion of an unwholesome working conditions. This concludes my testimony. I'm prepared to answer any questions.
You mentioned sewer, connected to a sewer. Does it have a septic system, or is it connected to an actual sewer line?
My understanding is it's connected to a sewer line.
Kate, can you confirm that?
I would have to double check, because something can be in the sewer service area without being on public sewer. I don't know offhand.
It's possible that's when Bell Labs got its dedicated line, that building also got the same dedication. I don't know that for a fact. That's my understanding, and I see somebody in the audience who knows also shaking his head. Yes, that's what happened. I think the municipal building may be connected to that too.
That's when they retired the septic field.
Right.
That's not official. You're not on the record yet, but that's when the septic field, as I'm told, was retired.
Okay.
So that dedicated line has its own issues, which, would have to be investigated too for any reuse, whether that's permitted or not, or any expansion capabilities. We don't know that here, and that's not what we're here for.
That was not part of the scope
Yeah,
of
so just
this
keep that in mind,
investigation.
but at some point in the future, somebody's got to decide that.
Yeah, I got a question. I got a few questions. You were on site August 22nd?
August, yes, that sounds
Yeah.
right.
Just
August-
curious, how long were you on site for? How long were you on site for?
Hour and a half, 2 hours.
Okay, so in an hour and a half, you were able to assess the structural soundness and the water tightness of this entire building and the entire property?
I looked at the building and did not see any evidence of leaks. Yes, we took a walk through. I looked into each of the rooms.
Did you do an infrared of the roof?
I did not.
Did you do probes of the roof?
Did not.
Did you look above the ceiling on the entire top floor of the roof, of the second floor?
You could typically tell from when you have the ceiling tiles if there's any stains and that kind of thing.
Yeah, if they drip onto the ceiling tiles, right?
Well, they typically find their
Well,
way in.
I'll disagree with that. But, and you checked the structural adequacy of the entire building? You said it's structurally sound throughout?
So no evidence of any failure.
Okay, well, it's a pretty big building. And I know you're an architect, but you have the background in structural engineering and to determine if there's structural conditions that warrant repairs? There's no cracks in the masonry, there's no cracks in the CMUs, nothing?
I did not observe anything
Okay.
of significant.
Okay, all right. I'm just trying to say, because you were there for an hour and a half, and it's a big building, it just seems like it's a pretty, like, pencil whip type of report, to make a bold statement or a general statement that everything is perfectly fine, so.
I'm not sure if I said perfectly fine, but I did not see any structural issues.
Well, you said there was no structural issues, it's in very good condition, there's no leaks, there's no signs of anything, and you were there for an hour and a half. Okay, all right, thank you, no further questions.
I just have a quick question. Why is it necessary to tell us that it's your understanding that an offer was made on the property in March of 2023 from a potential buyer for the use of light manufacturing?
Because someone was interested in using the building in the condition it's in now.
So,
Listen, he's allowed to give his opinion, or if that was he heard, but there's nothing before us that talks about offers, any other uses, so it's just, you need to take that for what it's worth.
right.
I would also note that that does not change anything about the applicable criteria.
Right.
Yeah.
I didn't understand the purpose of. Does the board have any other questions for this witness? Okay, then I will open this to the questions from the audience. Mr. Blumenthal.
Hello, Ralph Blumenthal. First, a question for Kate. I was surprised with your report that I didn't see any information like we just heard about the condition of the building. Was that intentional?
As a professional planner, that is not something I personally am qualified to make determinations on. In this case, we did not consult a structural engineer or a civil engineer. I did not think it was necessary given the status of the building.
Okay.
And I would also, note that my report does not make any assumptions about the structural integrity because that's not my field.
Okay. Nor am I an expert on it either. I've been involved with some construction. I'm not an architect, but I also was in the building in April for about 3 hours, meeting with Mr. Antala, and looked around at the building, and I did not explore every single corner either, but I can confirm that I saw no evidence of leaks, cracks, peeling paint. To me,
Question or statement?
okay. Yeah, if a question that has arisen, I haven't heard an answer yet. I have heard, are you aware if there's asbestos in the building?
I am not aware of that.
Because I've heard the answer is yes, and then if there is asbestos, as part of a reuse or renovation, would the asbestos be removed?
It would be remediated, sure.
Yeah, and my understanding also, which you can confirm, is that well, in the case of a reuse of a building, you remove it. If you're going to demolish the building, you also must remove it before you demolish it.
I'm getting out of my area of expertise as far as the environmental issues. Some asbestos can be encapsulated, or if it's not friable, can remain. So I'm not absolutely certain of.
Okay, but
I would say, Rob, there's obviously standards set by the state.
Okay.
So they'll have, whoever's doing that, they'd have to comply with whatever
All
those
right, but
standards.
potentially the building might need some upgrading to the HVAC systems or electrical systems or ADA.
Again, the building was occupied a few years ago. I am not aware of any upgrades to the HVAC or the electrical. The ADA, the restrooms would probably need to be upgraded to meet the current barrier-free substrate.
So it would be relatively simple renovations to be able to reuse the building.
Yes.
Thank you.
Again, I would note that the reuse and structural integrity of the building was not part of my analysis and was not considered as part of the criteria for declaring an area in need of redevelopment.
Is there any other question? Please come up, state your name and your address.
I'm Jayesh Mehta from the media, TV Asia, Madison. The question is, this has been raised that in 1.5 hours, he said something like, has anybody from the board made an effort to go there and spend some time to look at the building to actually find out, or we're just going against one word against the other?
It's not a question against one word against the other. It's that we've recommended our professionals to do the work for us and come back with their findings. And that's what we're relying our decisions on, and based on the testimony that's here this evening.
Yeah, that's the
And we
process.
have not been invited to.
Okay.
But you just
You're
can't
not
walk,
being
you just can't
invited.
walk into a private
I
building.
can't walk into
So,
Nokia.
yeah, so who would be inviting you is the question, like, from the owners? Or
It's
they would
not
be-
the process. The process is to,
Just listen and.
it's the process that we've already been through, right? The planner
Right.
gives her report, her findings.
Okay.
We just decide whether her findings satisfy those criteria, make recommendations back to the TC.
Okay. Just wanted to say that.
Yeah, and I'd like to add that if someone else is going to present their findings, we have the right to question them on their findings. That's all.
Okay. Thank you.
Are there any other questions from members of the audience? Then I will close the question part of this meeting. And thank you very much, sir.
Thank you.
Now we go on. Do you have another witness?
I would just ask, you have one or two more witnesses, do you think, Mr. Grauer? Two. So I'm just, how long do you think your planner is going to go? I'm just trying to watch the clock here. It's going to be a while. So, I mean, the board may want to decide to take the owner first and maybe the planner a different time, or start with the planner. I mean,
I think the planner's more efficient. I think.
more efficient with the planner?
Yeah, yeah.
Less than
Okay.
an hour? I mean, not holding you to a time. I'm
Direct,
just,
yeah.
okay.
Okay.
I think it's up to you. The owner calls Peter Steck.
You swear to tell the whole truth, nothing but the truth, so help you God?
I do.
Okay, just please spell your name for the record.
My name is Peter Steck, S-T-E-C-K.
May we please have some background, your education, your qualifications, and have you done many other redevelopment plans for other municipalities?
By way of education, I have a bachelor's degree in civil engineering and a master's in city and regional planning. I was licensed as a planner in 1976 and still hold that license. In terms of experience, I've worked with two consulting firms, Malcolm Kassler Associates and Alvin Gershon Associates. I was the planning director for the Township of Montclair for just short of 10 years. For the last 25 years I've been self-employed as a community planning consultant. I have testified as an expert planner in approximately 200 municipalities in New Jersey, in Superior Court and in tax court, and I've appeared and been accepted as an expert witness with respect to blight studies around the state, and been accepted as an expert planner in evaluating the validity of those blight studies.
Thank you.
Just for the record, can you define what a community planning consultant is, or is that?
It sounds nicer than a city planner.
Okay.
But I'm a sole proprietor, so you're looking at the entity.
Mr. Steck, did you prepare a report in this matter?
I did.
Sorry. And we've already marked that as 01 for the record.
Okay. Can you identify 01?
Yes, it's a report that I prepared, and it's dated today.
Why don't you take us through that report?
Okay. I will gloss over some areas, but I want to emphasize certain conclusions. As you know, this property is owned with two other properties. This is Lot 7, that's the subject of this evening, and Lots 6 and 6.01 are under the same ownership, but they have a combined history. As you know, that they were used as a unit for a number of years. The governing body first looked at this as an area in need of redevelopment without condemnation, and this it subsequently switched to a condemnation area in need of redevelopment investigation. In either case, if you want to have a redevelopment plan, you don't have to have a condemnation area in need of redevelopment. If the governing body said, we're going to evaluate this as a non-condemnation area, you still have the ability to have a redevelopment plan just for this property. The difference is obviously that if it's a condemnation redeveloped area, the governing body can elect to use eminent domain and take the property from the owner, despite the owner wanting to develop it on its own, and sell it to another developer. So there's obviously a major difference in terms of the motivation of a property owner when it is determined to be a condemnation area. That's usually I don't get hired when someone's doing a non-condemnation area because it may lead to an incentive for the municipality to do a special zone to encourage other uses of the property. But when you have it as a condemnation area, it suggests that the municipality may in the future have someone else in mind and wants to condemn the property and transfer it to another developer. As I will speak in a couple minutes, although this investigation is only of Lot 7, the fact that Lots 6 and 6.01 are being looked at as acquisition by eminent domain is a factor because, for example, 30 parking spaces are on Lots 6 and 6.01. So if the municipality goes ahead with condemnation of that property, we just lost 30 parking spaces. And by the way, we lost our air handling unit that's up on the hill. So there is an interrelationship, even though the only thing being investigated this evening is Lot 7. It is important, and I reproduce part of the legislative intent on the second page of 01, and it says, in terms of the purpose, have existed and persist in various communities of the state conditions of deterioration in housing, commercial and industrial installations, public services and facilities, and other physical components and supports of community life, and improper or lack of proper development, which result from forces which are amenable to correction and amelioration by concerted effort of responsible public bodies and without this public effort are not likely to be corrected or ameliorated by private effort. So the intent of the redevelopment statute is to address situations where the private marketplace is not going to remedy the conditions that are observed. If the private marketplace, in my opinion, is operational, a property isn't blighted. And blighted, although it was referenced earlier as the colloquial term, that's the constitutional term. When you declare this property in need of development, need of redevelopment, you're declaring it a blighted property, as that term is used in the state constitution. I did review the report, and several just general observations before I get to my conclusions. Criterion A or B are the only criteria that are addressed. This is characterized in the report as a laboratory research facility, and that's what it is. It has accessory offices. It doesn't produce a product that you sell. It doesn't manufacture a product historically. This was a research laboratory, so we had rooms that are somewhat larger that happen to be used for research. You can pull out the shelves and you can use them for other purposes. There are smaller offices, just under 100 square feet. You can shop for cubicles now that are 8 by 8 feet in an office building. This happens to have closed offices, but it is indicated by the architect. These are movable walls. It doesn't mean that someone purchasing this building can't move a wall or take out a fixture or a shelf to have it reused. The master plan confirms that this is an RL40 zone. It was recommended, and again, repeated are the words laboratory research. That was the historic use of the property. That's how the master plan refers to it. That's how the zoning ordinance refers to it. There is a small portion, 1.3 acres, that is in steeper slopes. That is wooded, doesn't need to be developed. There were 125 employees. They reduced over the time. That doesn't mean they were reduced because of the conditions of the building. That was simply the marketplace at the time, meaning that Nokia was relocating employees. That's not a factor. There's no evidence that that's a factor related to the conditions of this property or is this building. The offices are referred to as small, and yes, there are small offices, about 94 square feet, which is not a small office in my opinion. Again, you can go out in a large area and buy office dividers of 6 by 6, 8 by 8, 10 by 10. This is not an unusual space. What is interesting about it is, except for I think 4 offices, everybody has a window. Now that's kind of nice living if you're in some new office spaces that just have office dividers. You get to look out on a fairly well-wooded site. The focus of the report is on the fact that this was used for office and research, and the claim is, well, it can only be used for that purpose. And because of that, it's obsolete because of the way that it's cut up. I spent about an hour and a half in the building. I went through every corridor. I went on the roof. I also was on the site for a total of 3 hours. I saw no evidence of cracked walls. I saw no evidence of water damage. I walked around the building. I counted the parking spaces. As you can see in the photographs in the back of my report, which are Appendix B, the design is a modern design. There is a band of glass, 2 bands for each floor. The front portion of the building has 2 floors, and this finished facade is both on the front and back of the front portion. I walked the roof, I walked the back area. It hasn't been used for a couple of years, and I'll talk about why, in my opinion, it hasn't been, but in my judgment, it is a serviceable building. And there's nothing wrong with moving a wall. In the laboratories, they're basically open rooms, and some of them have trays for like electrical cables. Well, you take the trays down. Any new user to a building is going to change the accoutrements within the building to fit their new use. There hasn't been any crime, any vandalism for at least the last year. When I looked at the main building, I saw 2 areas of graffiti. And I would suggest to you that if graffiti on a building indicates that it's blighted, I can give you cans of spray paint and you can go around and blight anything that you see. That's not a threat, in my opinion, to public health, safety, and welfare. There's some discussion in the report about what the master plan goals are. Every municipality wants to spruce itself up, have good ratables, do what it wants. That's unrelated to the purpose of this investigation. You don't do redevelopment because you have a secret redevelopment plan in mind. The focus is that you found blight and you want to eliminate it. That's the purpose of the redevelopment law. It's up to the governing body to decide how they want to do it. They may want to have special zoning, but that's the second phase. The focus of this is the property blighted as of today? Does it meet the statutory criterion? Now, again, I looked at floor plans of the building, which are included in my report. I calculated the square footage. The smallest offices, except maybe one, the smaller ones tend to be about 94 square feet, which is not a small office space. And again, these are spaces that are attractive in that they all have a window to the outside, except for, I believe, 4 offices. I calculated a first floor gross floor area of 20,878 square feet, second floor of 29,209 square feet, so that's a total of a little over 50,000 square feet. 82 parking spaces in the front, 4 in the back, and 13 on the other side of the access driveway. There are 2 access driveways that go up to the top of the hill. And as I mentioned, there's a ancillary parking lot of 30 spaces that would be cut off from this property if and when the town condemns lots 6 and 6.01. If you go in the back of the building, across the driveway and up the hill are 3 large air handling units for this building. So if Holmdel condemns that property, we've lost our ability to air condition the building, or we'd have to reconstruct all of that. A significant feature is the RL40 zone. The 3 lots that we've been talking about is the only RL40 zone in Holmdel, and it has very, very restrictive uses. Essentially, except for uses by the township, a church, and a child care center, here is what is permitted. Laboratories devoted to research, design, or experimentation, and fabrication incidental thereto, and such other buildings as may be needed for protection and operation of the premises. That's not a manufacturing facility. A manufacturing facility is not permitted in the zone if it just does manufacturing. If it has a small component associated with the research, as in the pilot plant, that's okay. But this has an extremely limited zone. And the reason I bring that up is because while the marketplace has changed, your zoning hasn't. If it's acknowledged that the market, at least in this part of the state, might be weak for research and development, one solution is to change your zoning so it complies with what the marketplace is looking for. To retain this zoning, in my opinion, is highly restrictive in the use. Now, you could say someone can go for a use variance. That is sometimes a risky process. And in fact, if a municipality doesn't want the value to increase, they would not change the zone. It reminds me of Hoboken in the northwest section where you have industrial zones, and there hasn't been a new industrial use in 20 years. But the reason they keep it industrial is it holds down the property values there until they want to acquire it. The master plan, while it wanted to change the name of the zone, the governing body elected not to change it. So it's still a very limited ability to use this property for a permitted use. So here are my planning conclusions.
That's on page 11?
Yes. So they're numbered 1 through 7, and I'll summarize them. Although it's been a difficult market both to get municipal approvals or get municipalities to meet during the COVID period, and obviously it's changed the marketplace in terms of people wanting office space. Despite that, there have been interests by developers in using this property. Early on, when the applicant purchased the property, TV Asia was interested in leasing a portion of it. So they looked at the building and decided, we'll take whatever it was, the left wing or the downstairs, 9,000 square feet of it. So they looked at it through the marketplace and decided that this was a good site for them. And it's a very elegant site. As you know, driving by, there's a detention pond in the front. It's got a wooded surround. It's got a nice lawn. No one driving by this property today would think it's detrimental to the area. It looks nice, and the building is hidden behind a nice screening of woods. That TV company needed occupancy in the relatively short period of time, and they were informed that you have to go for a use variance. So they decided not to go ahead with this lease, and they found another place in New Jersey that they moved. There was a dental products company that wanted to purchase Lot 7 for their light manufacturing use. There were negotiations. They were near final, but then came the effort of Holmdel to condemn lots. First of all, lots 6.01 and 6. So they're going to take away 30 parking spaces in the HVAC system. And there was talk about eminent domain proceedings for the property that they were looking at.
Lot 7.
Lot 6. So,
Lot 7.
Lot 7, excuse me, Lot 7, the one that's the focus of this. So,
This is set forth on page 12, number 4, right?
yes, but I'm jumping the gun a little bit in my numbers, thank you. The point being is that there are incidents where the marketplace is operational despite COVID and despite the restrictive zoning. There were people interested in using this property. The fact that the zoning is so restrictive, in my opinion, artificially constrains the marketplace. And I gave you my example of Hoboken with industrial zoning in the northwest section. There hasn't been a new industrial use in 20 years, but they keep it there for a reason, which I think is improper.
Could that by itself extend the Vacancy?
It clearly could, because it limits the type of users, and it means that someone has to go through the risky process of applying for a use variance, that with the knowledge that the municipality may be interested in condemning it. That's kind of a double whammy from someone that wants to purchase or lease the property. So there, point 4 on page 12 of 01 details the uses that I just referred to, the Asia TV use, and the dental product manufacturing and research use. These were legitimate interests from people, and the very actions that you're taking, that the municipality is taking by directing research on this, constrains what the marketplace can do. It chases viable users away. On page 13, I reproduce criterion A, where it says the generality of buildings are substandard, unsafe, unsanitary, dilapidated, or obsolescent, or produce any of such characteristics, or are so lacking in light, air, or space as to be conducive to unwholesome living or working conditions. So when something is obsolescent, it means it can't be used. Owner doesn't pay the taxes. No one is interested in it. As indicated by, in my judgment, walking through the property, as indicated by the architectural services that the owner has hired, in my opinion, the building is not obsolescent. Also as indicated by the marketplace. There were legitimate users that appeared and were interested in it. And again, the test here, the purpose of the statute is to step in when the marketplace is not operational. I would suggest to you, despite these handicaps of severely restrictive zoning, COVID-19, and the threat of condemnation, up until the last few months, there have been people interested in this building to reuse it. The courts have said that it's significant when you declare a property blighted or in need of redevelopment. And you can't just have a net opinion that says, in my opinion, it's obsolescent. You have to march through the standards, the physical conditions, the proofs. It is too important to just have, it's my opinion. I think you need facts to back that up. And the burden is on the municipality to demonstrate that those standards are met. Criterion B reads as follows. The discontinuance of the use of a building or buildings previously used for commercial, retail, shopping malls or plazas, office parks, manufacturing or industrial purposes, the abandonment of such building or buildings, significant vacancies of such buildings or buildings for at least 2 consecutive years, or the same being allowed to fall into so great a state of disrepair as to be untenantable. In my opinion, this is not an industrial building. In fact, if someone came in with a pure industrial use, they would not be permitted in this zone. This is not a commercial building. Your planner's report, your zoning ordinance, your master plan talks about this as a research laboratory facility. That's what it is. And it's not listed in criterion B of the statute. And the plain words are there. They could have said, you know, apartment buildings that are not used for 2 years. They could have had a whole host of things, but they had a specific list of uses that may have been vacant. And
Can I ask a question while you're on this point? This is the proper time.
You can.
Marty? Sure. So if research is being conducted for a company that makes money commercially,
yep,
that's not commercial.
In my opinion, it is not a commercial building. This, again, I think you have to look at the wording of your own zoning ordinance. Your zoning ordinance in some cases refers to the SIC Standard Industrial Code in defining what light manufacturing is.
I'm saying if we do, I'm not talking about manufacturing, I'm talking about research, like
Okay,
you said. We're
but
strictly on research, and we're strictly on, it was for, at the time, Nokia, AT&T, Bell Lab, whoever, you know, the owner was at the time, they were doing research. They were doing research to make money.
Yes, the fact that they make
And
money.
sell some type of product.
The fact that they make money is not an index here. Commercial is a type of land use.
Well, has anyone showed any interest for a permitted use?
The dental research and light manufacturing use was ruled by your zoning officer a permitted use in the zone, but because of these proceedings, it was mutually agreed upon that the interest would be revoked. So they stopped interest in the they wanted to buy the entire property, the entire lot 7, and they backed away a mutual agreement because of these proceedings. No one wants to go through a purchase price, put in improvements that fit their tenancy, and then have the property taken by Holmdel.
Well, Jennifer, I'm sorry, Kate. You know, I've seen laboratories classified under the use group of banks and other types of establishments. I don't know. I mean, I always thought these types of structures were classified under commercial in the building codes.
Without the benefit of a specific definition, I'm in agreement that commercial uses is intended to mean any non-residential,
right,
or non-residential money-making uses.
There's nothing in the statute that talks about profit or non-profit. It talks about categories of uses, and in my opinion, this use has been consistently referred to in your master plan, in your zoning ordinance, and in the planner's report as a commercial laboratory use. Maybe splitting hairs. They could have said that
You said commercial laboratory use, right?
it's a research laboratory. If this statute could have said any single-family house that's vacant for more than 2 years, it could have said a number of things, but it didn't.
Look, we all know these things are very general, a lot of them in nature, but I believe the intent, and I don't have your background, but when I hear commercial as an engineer and someone who deals with buildings for a living, I think of this as multifamily. I don't consider that commercialized. Single-family homes, I don't consider that commercial. But when I see other types of building structures like this, you know, I believe it falls onto the broad term as commercial.
The other thing I want to emphasize in the wording of the statute, it says that this vacancy for 2 years
We've already established
is in such a condition that it is untenantable.
That's not the way it reads. It reads or. Look, we've been through this.
We established this earlier.
Well, I'll leave it up to the attorneys to argue what the wording is. But in my opinion, number one, the intent of this, again, there was already discussion that you were saying, if I have a new shopping center and I can't find a major tenant for 2 years, someone suggests, oh, well, it's blighted. That's what the statute reads. But I think you have to color it from the intent of the legislation, which is to address situations where the marketplace isn't going to fill this building. And I would suggest to you that if you take the handcuffs off of the zoning, and now with COVID, at least the governor has declared the COVID emergency over, if you have reasonable zoning, this property would be used, this building would be occupied by another use. That's what the marketplace suggests. And that.
But is that what we're talking about
Yes.
here, right now?
Yes.
I mean, I don't know. I'm thinking this bottom paragraph here on page 14, I disagree with, I mean, the way you put it in there, and say, even assuming B were applicable to the owner's research laboratory facility, there is no evidence, let alone substantial evidence, that the facilities have been abandoned or been allowed to fall into such great a state of disrepair as to be untenable. Absent such evidence, there can be no finding that the property is in need of redevelopment under criteria B.
Yes.
And again, as we've pointed out, this point B here under 4 and Kate's report is from the statute, and the legislature, the way they spelled it out, put or instead of and. So
Well,
to me, let me finish my thought here. To me, that just, that kind of separates things. And or is.
I'll let the attorneys argue this, but in the case of the Galenton case, which had to do with criteria E, the Supreme Court said or was and in that instance. So I'm going to leave it up to the attorneys to parse that.
Okay. But not under B. None of that addressed B.
But
none of those cases, the ones you had mentioned.
The Galenton case, the court was interpreting E, and it had said stagnant or unproductive. And the municipality said we only have to find stagnancy. We don't have to find that the land is stagnant and unproductive because it says or. And the Supreme Court of New Jersey said that is unconstitutional, therefore we're going to construe it as meaning and. And the statute was changed to say and. This is in pari materia. It should be interpreted the same exact way without a finding that this property has been allowed to fall into such great state of disrepair as to be untenantable. It cannot be blighted, and if you find that without that, it's going to be reversed.
But that's your opinion.
Based upon rational legal argument and a Supreme Court opinion that has interpreted this exact same statute as...
Okay. Bob, I'm saying that's your opinion. That's your opinion.
Opinion for criteria E, so.
Okay,
that's-
for criteria E.
We don't need to keep belaboring that point.
I would also just note for the board's reference that, again, the Galenton case was in reference specifically to criteria E, and that criteria B was adopted by the legislature many years after that. So they'd had the benefit of the Supreme Court's decision there.
B was amended after that, but it was there for a long time. The last point I wanted to raise is that, in my opinion, the board has to find that these conditions, the fact that it's been vacant for 2 years, it results in some detriment to the surrounding area. So to the back of this area, we have lots 6 and 6.01 that are owned by the applicant, and then we have Parkway property. Across Holmdel Road, we have a linear lot owned by the municipality with houses behind it on Longview Drive. They're all well maintained. To the south, you have a tree company that has big equipment, right? They have piles of mulch that they grind. There is no evidence, and the taxes are being paid. The property has been secure for more than a year. The question I would ask you, and the property looks nice. Someone driving down Holmdel Road would think that's just a corporate office campus in the background. You would not know anything different. So the question that the statute asks is, what's the detriment to the community of these conditions? And I would suggest to you that there is none. We pay taxes, the property is secured, there are no outstanding violations, no health code violations, the building is sound, it's secured. What's the detriment? I see none to the health, safety, and welfare of the community. So in my opinion, this property does not qualify for designation as an area in need of redevelopment under either A or B.
You done?
Thank you.
Just one clarification, I think. You said the property across the street was municipal owned. I believe that's privately owned, 800, if you're talking about 800 Holmdel Road as privately owned?
Let me,
It doesn't, I don't know if that changes your opinion, but I'm just,
Marty, I would just note that, that the opinion of Mr. Steck with regard to the detriments to the public or surrounding area, that language is not anywhere in
well, we're
criteria
gonna,
B.
yeah, we're definitely gonna ask for your counter comments in a second. I just want to clarify that one piece, because
there, if you look on page 9 of 01,
Oh, he's referring to are you referring to the buffer strip?
well, it's a lot, and it's I guess you could call it a buffer street, but there's a wooded lot owned by the Holmdel.
Okay, so the, with the R40A, that's the piece I'm talking about, that's privately owned. So where actually it says R40A, it looks like it's clear, it's right above that piece you just said. So there's probably both the municipal piece and...
Well, there's, right across the street from the driveway to this property is municipal wooded property. But on Longview Drive, they're single-family homes. As you know, they're all well-maintained. There's no evidence that there is any detriment to the surrounding community, in my opinion.
So, the questions of the board for this witness?
Yes.
And then we should ask for, well, you can do that first.
I'm going
Kate
to.
give her response first.
I have
Do you have questions? Go ahead, Ron.
just a clarification and then a comment. Mr. Steck, on page 12, number 3, you say that the town is in the process of trying to acquire 7, as well as 7, 6, and 6.1. I'd like just note that the township, as far as I know, is not in the process of trying to purchase lot 7 for eminent domain. You say it's all 3 lots.
Well, as I understand it, they're in the process condemning lots 6 and 6.01, not via the redevelopment statute, for a public purpose, like parkland.
Well, you say that it's the township's intent to utilize eminent domain to acquire lot 7, as well as abutting lots 6 and 6.01 in block 27. That is substantially not true.
Oh, they are.
The notice for this proceeding says eminent domain.
No, we're talking about number lot 7, block
Eminent
27.
domain. The notice says eminent domain.
This study is a condemnation redevelopment study, which means that if you conclude that this property is an area in need of redevelopment, the governing body is free to use eminent domain powers to acquire it.
But we're not saying it should go to eminent domain. Eminent domain is not being discussed here.
It is important because the courts have said it's so important, you've got to put it in your notice, even though you haven't even developed a redevelopment plan. It's that important that you have to put it in the public notice.
Okay. Do we want to introduce the public notice?
I would just note that the condemnation qualification for this study, it is an option.
It's not a foregone conclusion that this
No.
is
It says
what's going
intent.
to occur. If this is,
No, that is not, there has been nothing related to intent. It is just preserving the option.
that's just an important point to clarify.
Yeah,
Thank you.
exactly. There is no intent. It's an option. That was my first clarification.
The answer is, in my opinion, if this is declared in need of redevelopment with an option for condemnation, it doesn't condemn the property, but the governing body has the freedom to condemn it, and it doesn't have to make any proofs. If this is an area in need of redevelopment for condemnation, the governing body at any time can say...
For redevelopment, not for condemnation. That's not...
Yeah.
We're not the governing body.
I understand that, but...
I think the board member just clarified your statement was improper.
I'll grant you that this doesn't automatically mean that the township would use its eminent domain powers, but if this is declared in need of redevelopment with condemnation, it has the complete discretion to do it at any time.
It's an option, okay.
And it's
Do we have that option if we do nothing for eminent domain?
Not the same as lot 6 and 601, right? That's a public purpose.
I think that's a different conversation for them in these proceedings.
just-
Yes, no, and I agree with the correction that you made, that is an incorrect statement of the township's
That was my,
intent.
that was my,
I would also, just as a reminder to the board, the condemnation factor, the condemnation designation here has no bearing on the criteria as it is applied.
Any other questions?
Yeah.
hold on, I'm not done, I got two more things, quick. You also mentioned that if it was proceeded, you would lose 30 parking spaces. You did say
Yes.
that, right? However, there's plans in the public domain out there that if it's remained, the present owner has plans to build 25 townhouses. So clearly losing 30 parking spaces is not a detriment to your client. Would you agree with that?
I would disagree with that because it's needed for the building. The building has 90 parking spaces now, I think 99. To lose 30 is significant.
So 20 townhouses would still have 60 parking
the
spaces.
townhouses.
There's plans for 20 townhomes, correct?
That's before the governing body decided that they wanted lots 6 and 6.01 for parkland purposes. That's where the townhouses were going to go. That's off the table now. You don't. That's
So there isn't, what is the plan currently, as it stands right now, for development of lot 7?
Ron, I don't think we can't go there. That's not part of this proceeding.
Fair enough. One last comment about, there was some interest in the building and it was abandoned. I just want to state for the record that the tenant that you put in your brief here is TV Asia USA. I'd like to say that TV Asia is recording us, a film crew from TV Asia USA is here tonight. So I would just state that there clearly should be, it seems like there is still some intent from TV Asia USA as a tenant, just as a matter of fact, because
just because they're here covering the news, I don't think so.
I've been to every, yeah, that's it. They have the right to come and cover everything, but I've never seen TV Asia USA in any other meetings. Just want to state that for the record, for the people at home.
Yeah, I got a question. You've been doing this for a long time, right? You said that?
I'm 75, thank you.
Right. Have you ever found a building classified as blighted in all your years?
Yes.
How many?
An individual building I have, but when municipalities ask me, for example, Randolph a number of years ago asked me to do a redevelopment study, I'd say I'm not
It's a simple
because
question.
I don't think I can demonstrate that it's blighted. So they got to hire another planner.
Right, so you're 75 years young, right?
Thank you.
And you're saying in all those years, there's never been a building you found to be blighted?
I see lots of buildings that are blighted. I live in Maplewood. I'm right outside of Irvington. I have a couple projects in Irvington, and some of the areas there, in my opinion, are clearly blighted. I haven't been asked to do a study of them, but there are blighted buildings out there.
Look, we all know there's blighted buildings. I'm asking you, in all your years of doing this, see, look, I do a lot of expert witness work, and sometimes there's guys they call hired guns, right? Lawyers all know about that. So I just want to know, are you the guy they call when they want to just show people that they don't have a blighted building? Like, how many times have you said, yes, you're right, this building's blighted?
I have declined jobs because I thought that the buildings were blighted, but this is a process that, in my opinion, is abused by municipalities. I just looked at a site in Perth Amboy. It's an old industrial building that has 144 employees. They launder linens for hospitals. 88 of the employees live in Perth Amboy. Most of them walk to work. What does Perth Amboy want to do? Declare it blighted and replace.
Look, we can't speak to other municipalities. I just asked you a simple. The answer is no.
The answer
right?
is there are some jobs I will not accept because I don't think that properties are blighted. There are some properties that are blighted, but I tend not to work for municipalities for whatever reason I choose. I like to be, I make my own judgment, and I believe that I try to be a credible witness. And the standard here is substantial, credible evidence. That's what you have to determine to declare this property as in need of redevelopment.
So you would agree that if this building is deemed to be one of those types of uses enumerated under subsection B, that you would agree that it is vacant for 2 years and it would be deemed blighted, however, you may not agree with it per that statute?
No, I think that you have to, your even planner admits that you have to look at the details of it, and in my opinion, you have to look the intent of the statute. Is the private marketplace not operational because of the conditions of the property in the building? And I would say it is operational and it can be tenanted. Just take the handcuffs off from the restrictive zoning.
Like when it comes to the zoning, it's nothing to do with us, but I could tell you most people, when they buy buildings, they can't buy a building with the assumption that they're going to have the use changed because the market changed. I don't know if that generally happens, but I'm not aware of that always that happening. So,
question? Earlier in your discussion, you talked about the suffix of condemnation, whereby the township has the ability to transfer the property to another developer, a different developer. Now, is the original property owner compensated or made whole when that transfer takes place, or is it just taken?
Oh, no, they have to provide just compensation, and that's, as you may be aware, usually a major battle, because the municipality thinks it's worth $1 and the owner thinks it's worth $6 million. So you're right. The Constitution says that if you do take the property owner must receive just compensation.
The focus of your testimony has to do with the existing building being able to be slightly renovated and reused, notwithstanding the fact that it has no air conditioning and heating now, because that's
it does have the it does have heating, air conditioning, and municipal sewers, and it has more electric than you could ever want in your life.
So the whole focus has been on sort of reuse of that building.
Yes.
Using that building. Okay. And then now I'm looking at attachment F, chronology, and it talks about well, there's no page number. It's F. September 2020 meets township officials discussing development with residential use. June, building age restricted townhouses. December, I guess, 2020 maybe, presents residential concept plans for 88 age restricted or 58 townhouses. And then November 2022, age restricted housing.
And that was on the entire 3 lots. That wasn't just lot 7.
Okay. So with the change in the landscape now, as far as you know, the redevelopment with a residential component is completely off the table? It won't work?
It is.
Wes, we can't go there. That's not
Can't
part
go
of these
there.
proceedings. I mean, I don't know the answer to that, and it shouldn't be part of the board's consideration.
As I understand it, the Holmdel has the absolute right to condemn lots 6 and 6.01 because it's for a public purpose. It's for parkland. There's no debate that that's a legal action by the township. There are subtleties involved, and if the township wanted to acquire lot 7 for parkland, we wouldn't be here. The question is, does it meet the redevelopment statute? Because that's not automatically a it is a public purpose, but you have to meet fairly definitive criterion in order to condemn his property and sell it to another developer. And that's what we're talking about this evening. There's certain proofs, and I don't think they're present.
And part of that is the fact that it's not defined as office. We're talking about office laboratory versus commercial versus industrial, right? That's part of it.
I'm, again, the statute B didn't say uses such as, or uses akin to, or the generality of. It listed specific uses, and in my opinion, this is not one of them.
Thank you.
Any more questions from the board? I'm going to open up the...
Joyce, would you mind if I just offer a very brief rebuttal?
Bridget,
Yes.
go ahead.
Okay. I will be very brief here.
Take your time.
The first is that, I do stand by the inclusion of criterion A in this study. Obsolescence is a term that I don't remember the terms that Mr. Seck specifically described, but it is a term that means it is out of date, it is outmoded, and with regards to the unwholesome working conditions, I stand by what I say in my report. And then with regards to criterion B, I think that we've gone over this tonight many times, and I disagree with Mr. Steck's opinion that the laboratory research use is not included in any of the broad categories in this section. I believe it could be considered a commercial use, it could be considered an industrial use, and I don't think the language of the Holmdel zoning ordinance has any bearing on that. Secondly, I also disagree, as I mentioned before, with the assertion that or same being allowed to fall into so great of a state of disrepair as to be untenable. And to go, to speak to the purpose of the initial blight law, as Mr. Steck mentioned, forces that are amenable to correction and amelioration by concerted effort, without likely to be corrected or ameliorated by public effort. In my opinion, the state legislature, when they amended criterion B to include the provision, to include significant vacancies of buildings for 2 years, their intention was that rises to the level now. While it may not be necessarily the same kind of blighted building as Mr. Steck was speaking of, by the legislator adopting and amending this, it rises to the level, in my opinion.
Okay. Is there any questions from the audience? Then I'm going to close this part of the meeting. Oh, I'm sorry, Mr. Glee. No, for questions. He's going to... questions for him. Hello. Hi, Mr. Glee.
Hi, Kenji, number 8 Say Street. I just want to premise that I am not a community planner. I'm not a city planner. I'm not a structural engineer, architecture, or anything. I'm just a Holmdel resident. But I do have a question, and maybe it's a commentary, but on one hand, what I'm hearing is that in your report, you conclude that the redevelopment conclusion reached by our planner is incorrect. And there's very technical reading of certain sections and so on. On the other hand, we hear a lot of arguments about how restrictive RL40 is, the current zoning. And the question I really have is, it seems like you're talking on both sides of the argument here, that it's a very restrictive ordinance that we currently have. And it seems like redevelopment would be a nice way out of that versus for a layman, sort of spot rezoning. So the question is that you think an owner would buy the property knowing that it's a very restrictive RL40 ordinance and maybe take the risk of going a land use variance before a zoning board or try and convince someone to do a spot rezoning? I'm not sure.
This is spot zone now. These 3 lots are the only R4 zone in all of Holmdel. This is spot zoning now. Now, the prior owners, since they used it for laboratory and research, was happy with it because it was drawn specifically to accommodate that use. But marketplaces change. That's why you have to update your zoning every once in a while. And in my opinion, one of the reasons why this is not as marketable as it could be, because the zoning is wedded to the historic use, which is not necessarily the future reasonable use of this building.
Kate, is this spot zoning?
I can't speak to that. In my opinion, no. I don't know the history of this zone. I don't know if it applied to other zones in the township. I don't know how it got there. Yes. I would also note that the township zoning does have a presumption of validity, given that the township reexamines their master plan most recently in 2020.
Right. Thank you.
Thank you. If I may follow up.
Yes.
So some of the examples you use when you make the argument that the land is or the property is operational, and that includes, for example, a lease that have been proposed, and also an inquiry into light manufacturing. And yet, in my layperson reading interpretation, I believe an error was made in the original opinion that light manufacturing is allowed, because the manufacturing that was cited in RL 40 is for the purpose of the research. So if we need to make something in order to do something, for example, a part for a, who knows, a horn antenna or something like that to listen in, they would be allowed to do that, but those are kind of one-off original designs and so on, as opposed to making maybe hypothetically toothpaste or something like that. So for what that's worth, it just seems like that's the arguments that, the property is operational seems to have some holes in there as well. Thank you.
Thank you. Mr. Blumenthal?
Ralph Blumenthal, 41 Stony Brook Road. Just as a follow-on, Kate, you're familiar with the history a little bit about the property. I believe in your document you indicated that Bell Labs started using and acquiring some of the property on Crawford Hill in the 1920s?
I may have said 1920s or 1940s, but yes, in my research it did go.
When did
further.
Holmdel first have a zoning ordinance?
That I cannot answer.
I think it was after the 1920s. And hence, the use precedes the zoning ordinance, is my gut, that the zone was created to recognize the ownership and the use that was there. But that's a gut. I mean, it's a historic question. Yeah. So this is,
yes, again, this isn't directly relevant, but yes, my research did show 1929 there was a facility on this site. Wait, no, sorry, 2029 was the site of Bell Works. So this site started to be used in the 1950s. But again, to keep a narrow point that this is whether or not this is a pre-existing anything, it is not relevant to the study tonight.
Thank you.
Are there any other? Yes, sir. And then you in the back.
Patrick Tresquita, 56 Line Road. Just a point of clarification. The Crawford Hill property was bought in 1945.
Your question?
The question is, you referred to 1929. My question is, do you mean when AT&T purchased the property in 1945 to do radar research?
No, as a
War
correction,
II?
if you read what I actually wrote, and it's contained in this, is that in 1929, a facility was established on what is currently the site of Bell Works, and that was just to give context to the fact that Bell Labs used to have a larger presence in the township.
Okay, thank you.
Thank you. Yes?
Karen Strickland, 26 Hayward Hills. I am confused in that if the zoning is so restrictive, why are you fighting the redevelopment plan? Because it seems like you would want a redevelopment plan so that you could change things up. But that seems the opposite of what you're trying to do.
The issue, if the municipality said, we're not interested in condemning your property, first of all, they could amend the zoning ordinance, they could amend the master plan and put a different zone on this property without, forget the redevelopment statute. Through conventional zoning, it's already separately zoned now, it's endorsed by the master plan, the property is particularly suited for certain uses. If the municipality said, we'll relax the zoning, or we find other uses that are better, we're fine with that. If the municipality said, we're not interested in condemning your property or having the power to do it, we'll give you an overlay zone, so you can use it for office research use, but you can also use it for A, B, and C. If they would expand what we could do with the property, that would be reasonable. The reason we're here is because this proceeding, if they declare it in need of redevelopment condemnation, the governing body has the complete discretion to condemn the property and sell it to another developer.
I would remind this board that that's not that the future of the property is not.
But
in
Mr.
question.
Speck, don't they still have the option to do that, whether
Yes.
that development,
But
whatever our
It
recommendation
is
is?
such an important factor that the courts have said, if you're going to incur or authorize the ability to condemn it, you have to tell the public about it in the notice for tonight's hearing. Even though you may never use condemnation, it's so important because it affects private property rights. The courts have said you must put it in your notice or it's defective. It's that important.
And it was contained in our notice, for the record.
Right. Are there any other questions? Okay, then I'm,
Of this witness.
yes, of this witness.
Close that.
Okay, I'm going to close this portion of the meeting, and it's 10 o'clock, and our meetings normally end at 10 p.m. So we're going to carry, yes.
We're done. No, we're done.
Oh, I thought you had one other
No,
witness.
we don't.
Oh, I thought you told me you had two
We did, but
witnesses.
we rest.
Okay.
Thank you.
Then,
Any other questions or discussions?
Right.
Let Kate sum up, or we have comments, we have public comments.
right,
Are you going to continue to another date, and when might that date be?
Not yet.
not yet. We're going to see if, is there any comments? Yes, Mr. Blumenthal.
Thank you. I was just concerned if you're going to continue to a date I wouldn't be here, and I couldn't make these comments. But I'll try to keep it brief.
You swear to tell the whole truth, better but the truth, so help you God?
Yes, certainly. Thank you. Ralph Blumenthal, 41 Stony Brook Road. I'm a trustee and the vice president of Friends of Holmdel Open Space, FOHOS, which has worked to preserve open space in Holmdel for 20-plus years. Contributed to the Chase Tract, to Neil Waycake Park next to Walaco Park, Callan Farm, Harding House, and more. We're prepared to do fundraising to support the establishment of a park on Crawford Hill, and I'll say a bit more about that. Kate's presented a study of the potential need to redevelop Lot 7 on Crawford Hill. To my mind, it's the wrong study. We don't need development or redevelopment, but rather reuse. For months, since December of last year, we and others have been advocating for the preservation of all three lots as a park with public access. We've got almost 10,000 signatures on the petition now supporting this. Many comments on the petition, and especially those from Holmdel residents, say we do not need more development in Holmdel of any sort, and especially at that location. Holmdel voters, taxpayers, have over the years supported 3-4 times now to create an increase in open space tax, as much as 2 years ago, to increase the municipal open space tax, and so they voted yes to preserve open space. Kate's report on page 2 says this area was previously developed as one cohesive site. And we heard more about that tonight, that the air conditioning handlers for the building are up on lot 6. Let's keep it that way. Most of the parking, the infrastructure, the utilities, and more are on Lot 7. The township, together with Monmouth County Parks, Monmouth County, Green Acres, have the funding to acquire this lot and to repurpose it as part of a public park for public use. Moreover, this recommendation is consistent with Holmdel's master plan. I commented earlier, we talked about the condition of the building, and I'll say a little bit more then about the reuse of the building. How would that fit into a public park? First of all, to reiterate, I recommend the acquisition of Lot 7 together with 6 and 601 for a park containing the high point of the county, the horn antenna, and more with public access. This wouldn't require any change in the zoning, nor would it support any new development. It's within the town can simply do that. And so I suggest no on recommending to the Township Committee that Lot 7 needs redevelopment. It doesn't. Regardless, you should, however you vote on that, I think you should suggest to them that Lot 7 should be acquired to be part of a public park together with Lot 6 and 601. How should we utilize the building? As a park office and more. Many petition comments and speakers at recent TC meetings have described how they've been inspired by what occurred here, the discovery of the Big Bang. It's been an educational moment for many people. Let's preserve and build upon the history-making research that happened here. I'd like to now introduce Fred Carl, who's the founder of the Info Age Science and History Museum at the former Camp Evans in Wall.
Is he going to make a comment? Because that's basically all we're hearing for two
Yeah,
minutes.
I thought you were asking for comments, yeah.
Yes.
For the board, before Mr. Carl speaks, I just want to remind the board that the adoption of this site, if you choose to pursue it, or choose to agree that it meets the criteria for an area in need of redevelopment, that does not change anything in the zoning at this time. Secondly, I would also note for the future that declaring a site an area in need of redevelopment does not require that the building be bulldozed. It does not require that a whole new use be put up. That a redevelopment plan can cover anything from any. There's no it can be for reuse or anything like that. So I just want to be clear that that area in need of redevelopment designation does not mean that the property will be cleared.
So I just add two more sentences, if I may. Anyway, Camp Evans in Wall is where Marconi did some of his research in the early 1900s. It became an army base, used in World War I, more extensive barracks in World War II, and then fell into disuse. In the 90s, Fred became aware of this and picked up more than just a baton, but became the founder of getting that property to come into public use and develop into a history and science museum. The former Army barracks that are there date from World War II. They're in much poorer condition than the building we're talking about here. And Fred will briefly describe his vision of what we can do here to enhance a public park with educational aspects for Holmdel. Thank you.
So just as a reminder, we're here, as Kate said, just to make that determination, whether we make a finding on her recommendations. So, I mean, what this may be or not, that's not for this board.
All this is for is to whether it meets the statutory criteria set forth in my report. And once again, I would note that we did hear prior testimony about some of the architecture and structure that was not considered in of the criteria.
Yeah, I would say that, well, whatever he has to say is really nothing to do with what our decision is, because it's about what we feel, whether it meets the criteria or not. You know, I believe that's the case.
The comments should be related to this hearing.
Right. The task at hand, as directed by the committee, is to make a recommendation as to whether it meets the criteria, the statutory criteria.
So do you have a comment relating to what our purpose is here?
For redevelopment.
My comment is, my name is Fred Carl, I live in Ocean Grove, New Jersey.
So Fred, just in case they want to hear you, let me swear you in, because it's a comment here. Raise your right hand. You swear to tell the whole truth, nothing but the truth, so help you God?
Yes, I
Just
will.
spell your last name for us.
Carl.
Okay.
And my comment is, this has the opportunity to take this to the next step, and here is a possible next step, if I could hand these out.
No, unfortunately, no.
No?
I think what we're saying, we're not here to discuss next steps or 15 steps. We're here to discuss whether, it's A or B, and vote, or eventually decide on one issue, not what it's going to potentially, possibly, may be used for.
Okay.
And unfortunately, but that should be directed to the TC whenever there's a township meeting. but
Yes.
not-
May I give these to you for
You can
future
give one copy to the
consideration?
board secretary, so she has it in the
Okay.
file. But it's not, we're not going to admit it as evidence.
Thank you, it's okay. It's all good.
Are there any other comments for the board for redevelopment?
Roberta Kaufman again. Oh,
Do you swear to
excuse
tell the
me.
whole truth, nothing but the truth, so help you God?
Yes, I
Thank
do.
you.
I think Mr. Blumenthal was stating the point that this is not a building that needs to be considered, or the lot, an area in need of redevelopment, because there is a use that is obvious to many of us for this property, which does not require rezoning or designation of an area in need of redevelopment. We have seen what happens when we do designate areas in need of redevelopment. But I just want to say that this is a unique property, and that the presence of the horn that gave us the echoes in space initially, the learning possibility for our teenagers to come to a spot and see that horn and see what it's very tangible. It isn't like a linear accelerator that's under the ground that the physicists have. That the potential of developing this as a science center for our children here in Holmdel and in the county is so overwhelmingly great. I just want you to understand that I would like to just convey that the property is ready for that kind of thing. The building, as we all seem to be concurring, it's now reusable. Obviously, it will take a great deal of funding. Mr. Blumenthal referred to the top potential of funding for this. We have almost 10,000 signatures.
Listen, I don't want to cut you off. It is 10:15 at night, and
Okay,
it's
Mr.
the
Silverman,
same
I
point.
appreciate your point of view. Thank you.
And once again, I would remind the board that if you recommend this designation, it is not saying that the building has no possibility of reuse.
Right. Okay, I'm going to now close the public portion of this meeting. Okay, right, board discussion.
Kate, I'm struggling with the 2004 master plan. And thank you for your plan, your presentation. It's awesome. Really tells us the whole story here. But you note that in the master plan, the idea was, quote, conservation of farmland preservation, parks and recreation, historic preservation, and others. Goal 4. I'm on page 7, by the way. Goal 4.J, protect the visual quality and scenic corridors throughout Holmdel, particularly vistas of open space, natural features, farmland, and again, historic sites. Goal 11.A, preserve the unique character, heritage, and identity of Holmdel for the benefit of future generations by protecting buildings and sites in historic Holmdel Village, this is not, as well as other buildings and sites notable for their historic or architectural attributes. If the horn antenna doesn't apply to what I just read, I don't know what site in Holmdel does. So I'm clearly struggling to agree that this should be up for redevelopment.
Okay, with regards to the master plan goals, the statement 4J with regards to scenic corridors, that was in reference to the fact that this portion of Holmdel Road was designated a scenic corridor as part of that plan. And that area along Holmdel Road is where the landscape easement and the steep slopes are in place. So that's the relationship with that one. And I will admit that goal 11A may have made it in here from a prior draft because the, the horn antenna is not part of this site. But again, this is really, these master plan goals are really just here for reference. Because again, we're not making, you're not here to make a decision on the future use of the site.
Is there any other discussion from the board members?
Yeah, so now you can, if I would do first a motion to approve or not approve, if it's to approve, are there going to be, I would then ask if there's any recommendations the board would want to make. So the next step is to make a motion, either to approve or not. If it's to approve, this board can then discuss any recommendations that they would make as part of that approval. Obviously, if it's a denial, there's no other recommendations needed.
Yes, I would just note, for the board, again, I'm sorry, I sound like a broken record, but it's in place of, approve, just approve, deny. I think the language to look at here is whether you agree, whether or not a motion to recommend to the township committee that the area, that block 27, lot 7 qualifies as an area in need of redevelopment.
But Marty,
And anybody can make a motion on either side, and if it's seconded, then there'll be a vote on it.
just Marty, given the fact that we presented new information at this meeting, I mean, does it have to be voted on at this meeting, or could it be?
No, I don't know if there's a timeline from the township. I'm seeing no from Mr. Baer. So we just got the planner report for the objectors. If you want time to go through it and consider all the testimony, we can come back. Yeah, I mean, I don't know if you need that, but
For the reasons I just listed earlier.
I mean, for the ownership here, I mean, if we wanted to come and tour the facility, tour the building, do you have any issue with that?
I don't think that's appropriate from this perspective, but I'll defer to the attorneys.
What?
Based on the comments I just made, I'd like to make a motion that I don't think this is an area in need of redevelopment. Can I make that motion?
Is there a second?
I can't, I have to review all the information and make an informed decision at this time. So,
the first thing is, if there's no second, then we need to either go to a motion to recommend with or without suggested comments, or as Scott's saying, whether the board wants to entertain an adjournment to another date. I'm not sure.
I'm in the minority.
Yeah, so you may want to poll informally the board as to if they agree with you or not. Or the chair, you may want to poll the board if you agree.
All right, let's show by hands.
I mean, if I'm in the minority, that's one thing, but,
Do you want
contrary.
to- Do you want to post more time? Do you feel that you need to review the documentation that's, you want to vote tonight? Jeff? Okay.
Okay, so the board's ready to vote.
All right.
So now,
All right.
I guess there's a question, is there a vote? Yeah. Was there a second to Ron's motion? I didn't hear it.
No.
So now we need another motion.
To make a motion to pass the redevelopment right? That's, or,
Motion to recommend that that Block 27, Lot 7 meets the criteria for an area in need of redevelopment, criteria A and B per the local redevelopment and housing law.
motion for that? I don't know. Well, but yeah, based on what I've heard today, and I still don't see how sub B has been proven to show it doesn't apply here. So I'll make a motion to, say it again?
It's a motion to recommend that the subject property, Lot 7, meets the criteria for
Local
condemnation with area in need of redevelopment, with condemnation.
Okay.
Under criteria.
With condemnation.
Yeah,
Okay,
under
with
criteria A and B.
Right.
Is there a second? Yes
or no?
It's just a motion.
It was a motion.
I made a motion to recommend that this building meets the criteria for condemnation or redevelopment. Redevelopment.
Do I have a second? Mr. King seconded.
What you mentioned before about recommendations?
Yeah, so just like when we have zoning hearings or planning hearings, you can suggest conditions. We can make recommendations that we think the plan should be tweaked in some fashion.
It's not a plan, it's a study.
I'm sorry, the draft study. It's a draft.
Does anybody wish to make a recommendation to Township Committee with regards to the recommendation of this redevelopment plan?
My concern is, I think this goes against the master plan from 2004. So I can't really make a condition that we recommend approval of redevelopment if it goes against the master plan, which I think it does.
Okay, roll call.
Mr. Ackerson?
Yes.
Mr. Fagan?
Yes.
Mr. Emma?
No.
Mr. King?
Yes.
Ms. Pelosis?
Yes.
Mr. Silverman?
Yes.
Any other business?
Do we have any other professional reports?
No.
Any other business?
Nope. Motion to adjourn?
Yep. Motion to adjourn?
Motion to adjourn.
Second. Show of hands? Huh? What? Oh, you're gonna, for the week? Oh, sorry you came back for it.